Thursday. We're in call to order for work session for the Woodland Park Planning Commission for Thursday, September 8th, 2022. I guess we'll take a brief roll call. Larry Larson.
Here.
Carol Harvey.
Here.
Ken Kennedy.
Here.
Shauna Nilsson.
Here.
And I think we have Lee online. Lee Brown.
Yes.
And Ken Hartsfield. I'm here. Please join me for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America.
States of America, and to the republic for which it stands,
Indivisible, with
indivisible, with liberty and justice for all.
Thank you. So we have a work session tonight. Is the only item on our agenda for short-term rental, reviewing the draft ordinance. And we do have Karen with us online. Are you there, Karen?
Yes, sir.
Did you have a presentation at all, or just ready to move forward?
I guess just real briefly, want to note what was in your packet. And that was a cover memo which summarized the history of all the various steps that we have gone through since at least May, and really starting back in November of 2021 with some individual one-on-one stakeholder interviews. There's been a couple of different things that the city has done to engage the community and obtain feedback and make sure we had a good understanding of issues and concerns around this particular topic. And then you all as Planning Commission have had a couple of different joint work sessions with City Council on this topic and have been part of helping formulate what you wanted to see in an ordinance. And so the most recent joint work session did involve looking at the initial proposed draft ordinance around this particular topic. There was some feedback that we received at that point. And then our city attorney, Nina, has gone through and incorporated those changes that came out of that particular work session. So the memo in front of you really tried to summarize a lot of what I understand at a staff level, the intent to be, and how this particular ordinance meets all of the criteria that has come out of those various work sessions and community engagement activities. So in front of you this evening should be a fairly solid draft that hopefully doesn't need too terribly much massaging or many changes to it. And at this point, we are looking at having a public hearing on the ordinance in front of Planning Commission at your next meeting on September 22nd. So with that, I'm not sure what the chair's pleasure is or how you want to dive into this, but if there are, I guess, issues or concerns at this point with what's in front of you, to work our way through those.
Thank you. What I'm thinking from discussion with some of the other commissioners, if we might go through and get general impressions and response to what we have in front of us, and state those opinions in the direction that we'd like to head individually. We do have some people in the audience, and as a work session, I would probably give the opportunity to get brief comments from the public and anyone who happens to be online. And then I think we need to go through the ordinance in a little more detail, going sections through section and see what comments and specific items may be needing further discussion or massaging or approval. With that, Mary, would you like to make any comments regarding the ordinance?
Sure, be glad to. Thank you very much. Well, first of all, I want to thank Nina for her excellent proposed ordinance, for review. Her expertise and experience working with this specific subject is so helpful. I appreciate it. So thank you very much. Also, I want to thank the staff, Karen and others. And I know there's quite a team that's been working on that and listening to our citizens and the commission and the council as well, and also presenting and making sure those provisions have been addressed in the code as well. And thank you for allowing the planning commission to actually review other provisions in the code that not directly relate zoning, particularly the business license. And that's appreciated as well because they are so linked together, and that's very important. So I've got a list of what I thought were some of my major concerns, so I'll go through those. I assume that we're looking at a short-term rental license, that one for business and another one for a unit itself. Because when you read through the code itself, or the proposed code, there were some, it wasn't very clear in all provisions which license we're talking about. So I'm just going to ask that we look at making sure that's very clear in the ordinance, which ones we're checking. I'm also going to be recommending tonight that the city clerk prepare and maintain a Woodland Park short-term rental unit application waiting list.
I'm sorry, can you repeat that last part? I was getting the packets out.
Okay, a Woodland Park short-term rental unit application waiting list. And I'll talk about that further when we get to that section where that's appropriate. But basically, you know, right now we've been working under if there's a business license that applied to short-term rentals. And I think it's very important that, in my mind, I think we're going to be reaching our capacities, our caps very quickly. So it's going to be very important that people that desire to have a short-term rental have the opportunity to get on a waiting list, to be able to say, are you still interested in doing this? We have an opening, if you will, and take a look at that. I'm also going to recommend that the planning department maintain a Woodland Park short-term rental unit inventory. We have a provision in here that says that we have a cap of 6% of our short-term rentals in specific zoning districts. We need to have a record of how we're going to maintain it and monitor that. So I'm going to be talking about that. I also want to address a little bit about the 50-foot radius separation between the single
500 foot?
500 foot. What did I say, 50?
Yes.
Woo.
Didn't know you're proposing a change or not.
Oh, I'm at 5,000. 500. I believe this is a very reasonable mechanism to maintain a neighborhood's residential character. And what it does, it provides a mechanism in which the majority of houses in a particular area will still be maintained for long-term ownership and rental. So I know we've talked about that before as a concern, and I just wanted to address it right off the bat that I believe that's a reasonable provision. And again, I believe the cap itself will encourage that a portion of our housing stock remain affordable and attainable by preserving the existing traditional residential neighborhoods. And I think that's very important. If by the information that we have received up to this point, there is a continuously increase in the number of short-term rentals. I think that particular mechanism for the cap will maintain our residential neighborhoods as residential.
Could you repeat the first sentence? I'm sorry, I just didn't hear it.
Okay,
Of that section.
okay. Basically, I said, I'll read what I wrote actually. The establishment of a short-term rental cap helps to encourage that a portion of our housing stock remains affordable and attainable by preserving existing traditional residential neighborhoods. I'd also like to propose, because of the lateness of the calendar year, by the time we get through this process, public hearing on the city council, 2022 will almost be over with, and we'll be beginning the new process of the new year. So if there's a mechanism that we can use or some kind of way that we can combine these two application periods that are so close together, I would certainly encourage that we try to do that. And that would minimize the confusion to the residents. It would lessen the cost for fees for applicants. And it may, the way the ordinance is written, if we say tell somebody in November, you've got to come in to maintain your status, and then turn around and say you got to do that in January, it may be a little unfair. So I'd like to explore that as well. The ordinance also has a provision in there talking about violations of the code, violations of the neighborhood code of conduct, if you will, and other provisions. And it talks about an existence of one violation is a major concern. I'd like to see maybe bump that up to a 3 strikes and you're out provision instead of 1. So that's a major thing I'm concerned about. Regarding the city zoning table of permitted uses, the term permitted conditionally is used to designate which districts would allow short-term rentals. The code does not provide an explanation what permitted conditionally means. We have one for conditional, and I don't think we have one for permitted either, but permitted is basically, you know, it's allowed in that district. It's not subject to a review by the Planning Commission, City Council for conditional use. So I would suggest that let's talk a little bit about in the code what permitted conditionally means. So one of the last sections of the ordinance is a section called Section 7, current business licenses. I found that section to be very confusing. I think I knew what the intent was, but I believe that what we need to do is take a good hard look at that. And again, if it talks about priorities, so on and so forth. And the question that I would have to Nina about that particular thing does the granting of a business permit or business license for a short-term rental during the year 2022, does that vest any rights with a particular property owner?
No, this ordinance makes clear that it's not, the licenses aren't transferable. It would be the same thing as a liquor license or any other business license. That's why we, separate that distinction between a zoning right and a business license right. And that's why we have those, like the violation and the renewal and the suspension to kind of keep the, to show that it's, not outward right. It's good to know about the permitted conditionally, but I think we probably should define that better in the code and still keep the PC so people know what it,
Yes.
that's always good feedback. Yeah, thanks.
Okay, thank you. And my last comment is just that we received this last week, the first time we saw this revised ordinance. It's obvious when I heard tonight that it's not available online for people to see that. I'm concerned about that. I would like to have the public have an opportunity to either review this particular ordinance or the ordinance that is created out of our discussion tonight, be available with significant time or ample time to review that and make comments. That's all I have.
Very good, Larry. Appreciate that. Want to walk down the aisle here. Ken Kennedy, have any comments at this point?
I have a list of suggested edits by paragraph that I would like to talk about. I don't know when we want to do that, probably more in the working session, but I have,
I guess we're looking for general comments now.
yeah, so
I've got
in general,
specific questions.
I've been through it. I'm ready to work on it. I'm happy to go over my suggestions on alternate language on some things. And if you want details, I can do that. But in general, I've got, about 15 paragraphs that I think could be modified to improve the ordinance a little bit.
I think we'll go through it more detailed.
Yeah,
kind of
like a line
section
by
by
line.
section.
That-
Take those comments down.
But
That'd be
yeah, I'm
great.
looking forward to it.
Carol, any comments at this point?
Well, first again, thanks to Nina for putting this together. I mean, it was certainly like herding cats to try to incorporate what I think was a very robust opportunity for the community to comment, for planning commissioners, for all the stakeholders. That I think that was a phenomenal effort, and thanks to Grace and to Rob Feltz. I understand Rob's gone now, but wherever you are, Rob, thank you very much for all of the work you put into this. And I would say that my first observation is a few months ago, it was what's broken and what do we need to fix? And I think my primary concern is that we simply didn't have a section of the code that addressed short-term rentals. This ordinance does that. I see no reason to prohibit short-term rentals, and I appreciate the fact that this gives us an opportunity to limit them through a percentage of some type. And I'm glad that we didn't go to a density percentage, because that would have just been incredible to enforce. And that would be my second point is, let's make sure we have an ordinance that's easy to understand and is also easy to enforce. If we keep adding caveats about you can't have a short-term rental unless your first name starts with an A and your last name starts with a Z, and you can only do it on certain nights of the week, we don't want to go that route. We just define a short-term rental, define how to license a short-term rental, define the department responsible for that short-term rental. If we want to put a cap in there, this ordinance does give us that opportunity to do so. We may bicker a little bit about the number of the percentages, and then make it clear to all of those that are impacted by short-term rentals what the city's stand is on it. And I think this ordinance does a really good job of that. I have a couple of places that I would argue about. There's a sentence in there about person controlling the corporate ownership must reside in Teller County. I'm not sure what purpose that serves. And then just a couple of other places that I would tweak. I've seen some of Ken's suggestions, and I'm anxious to let him explain those. But bottom line is, I think this is a very workable ordinance that will serve the community.
Thank you. A comment?
Just a couple quick ones. I also wanted to echo some of my fellow commissioners and what you've said and all the thank yous and hard work that you've had. I appreciate that. I would like to see a little more definition between someone who's only renting for a couple months out of the year and someone who's renting full-time out of the year. And I agree with Carol, who's going to monitor that? Who's going to make sure they're doing what they need to be doing? Are we pulling the license at that time and things like that? So otherwise, it's all been said.
Well, thank you. Lee, I'd like to give you the opportunity. Have any comment to share with us this time? Not hearing you.
I think you're muted, Lee.
Okay, how about now?
That's good.
Very
Thank you.
Okay, great. Thanks. I agree with a number of the comments about the fact that we made some progress getting to where we are now. Like Ken Kennedy, I have a number of specific comments on various paragraphs, which perhaps later in the evening we'll have a better time to get to some of the smaller items. I think the conceptual area where I had the biggest concern here was the failure to make a distinction in our treatment of owner-occupied units from non-owner occupied units. It was at least I felt I argued at both of our previous work sessions with the city council, and I thought there's some number of some significant support for the idea that owner-occupied short-term rentals should be much more lightly regulated, to the extent they're regulated at all. I am not inclined to support a limitation on the number of owner-occupied short-term rentals. To the extent that there are some other regulations of those short-term rentals I'm not enthusiastic. I could be, I could consider coverage of those, but I think at least the concept needs to be developed. I think there is broad support for it in the city council. So that starts with some definitions of what the principal or primary residence is, and then decide how those are treated. I would suggest that any caps that we're talking about apply only to non-owner occupied short-term rentals. All right. Well, anyway, that's a fairly big chunk just because it affects the numbers we're looking where the numbers we're looking. Oh, by the way, I'd also note, similarly, the 500-foot limitation that Larry commented on, I would think that would also apply only to non-owner occupied short-term rentals. And those would be a couple of examples of where I think it's more soft regulation of those is appropriate.
Thank you, Lee. Covered a lot of topics that I have here, and I do have some detailed items to discuss. I guess related to what Leo said, what about renting a room out? I'm saying that this is not regulated by this ordinance.
Yeah, I changed that since the last work session. Not that they can be changed back, but where it used to say a short-term rental unit was a residential dwelling unit or a portion thereof. So then we took the portion thereof out based on the council member Zulaga mentioned it, and then didn't really seem like anyone was against that, to say like you could rent just a room and then there's not the regulation. But of course, I take policy direction from you all.
So currently, it's not restricted by this ordinance. If I
Correct.
want to rent out my room for a couple nights.
Just a room, yeah, not the whole unit, not the whole dwelling unit, yeah.
So it's outside the cap of that. Still have a question about the Keller County residence issue, some discussion there. How new applicants get into the queue, whether there's a waiting list or lottery, like some discussion on that. And I guess more of it's more detailed issues as we get further into it. So we've kind of gotten through, everybody's got a feel of the general issues. I guess I would like to open discussion to people in the audience. If there's anybody who'd like to make comment, this would be an opportunity to express those. Oh, we don't even have a microphone up, but here comes Dave. He can help you out. Give us your name and address, and then we can see what issues you can bring to the table.
My name is Frances Maria Sennell. I live here in Woodland Park. I think it was established in 2019 that it wasn't necessarily required to give our addresses unless you insist. We normally have sign-up sheets, and I prefer that that's where my address go.
We can move forward then.
Okay. I think we're jumping the gun here. And that is, is the Planning Commission assuming that all of the residents of Woodland Park are in favor of this, or at least enough to make it a majority, and so that the Planning Commission and later the City Council will be acting on something that is good for Woodland Park and not bad for Woodland Park? And I am suggesting that this is bad for Woodland Park. I've talked to a number of my neighbors. I've talked to people at the grocery stores, Walmart, Safeway, City Market. Everyone that I have talked to, except for people who are going to make money out of this, are against it. If we take the number of, I don't know what the quota is or what the lottery is, but I can't imagine that it would be close to the number of occupants in Woodland Park. And that really bothers me. Also, I think we all have to look within ourselves. And when I say within ourselves, I mean you guys. And I also mean the City Council, as to whether you have conflicts of interest. And if so, you have to recuse yourself. And that means any kind of relationship with the business. And it is a business that is short-term rentals. And it's a business because at a very minimum, the homeowner has to pay state and federal taxes, and they are bound by state and federal taxes. I have not had a chance to review this in detail, but I suspect that some of the provisions are not in compliance with state statutes, and that has got to be accounted for. One of the things that Mr. Brown said was concerning to me. He said, to the extent that they are regulated at all, and I think he was referring, and Mr. Brown, please correct me if I'm wrong about this, but I want to know what will be regulated and what will not be regulated. I would appreciate if you would take down my questions, because I would really like answers to these things. If there is a significant conflict of interest, whether in this body or the city council, which in the city council there is, so that such that a quorum cannot be established to vote on this. So if the city council cannot act, this is dead on arrival. And no matter what this body does to put together something, it's most likely not going to go through unless the city is planning a lawsuit, which actually makes me, that concept is ridiculous to me, because if we have to file a lawsuit, the people who don't want this with the district court after this matter is reviewed locally, then guess who gets to pay for the city's attorney's fees? We do. We will not only have to pay for our own legal fees, but we'll have to pay for the city's legal fees. So we get double dipped, and that's definitely not in a good way. A couple of more points I want to a question that I want to ask is, in your due diligence, what have you done to make certain that the majority, at least the majority of the citizens of Woodland Park want this? Because I have not found any kind of majority, so the city government would be doing something that the citizens don't want. And this wouldn't be the first time. And it's time that the city start protecting the citizens of Woodland Park and not giving them something that is going to cause them a lifetime of a headache. The city also needs to consider what this is going to do to the school districts. How are we going to vet the occupants? What if we have occupants that have felony records or misdemeanor records as long as your arm, records of violence, records of sexual assault, records of domestic violence, records of violence and domestic and abuse against children in particular? How are they to be vetted? That is an important thing. One other thing I'd like you to consider is when people come up for a short-term rental, and I'm just going to make up an example on the spot. Let's say we get 20 people who want to occupy a big home. And from what I understand, there's some very large homes that are really on board with this because there's a lot of moolah to be made. And let's say they come up let's say they come up for the 4th of July and they spend a week and they shoot off a firecracker and it burns down the neighborhood because this is the first year in my 12 years here in Woodland Park that we haven't had a drought. We had a monsoon this year, but it's likely not going to happen again. So it is a great likelihood that the short-term rental tenants could cause a lot more damage than the city would be able to recoup with the 6.5% tax, which is laughable. It's my understanding that any other lodging business pays a whole lot more than that. So there should be insurance policies that the owners should be able to, or should be required to possess before they can get their license. And my opinion is it should be around $10 million in case a neighborhood is destroyed. Also, we have to consider that most of the short-term rental tenants are going to be from out of state. So if they damage a home, if they wreck the walls, if they leave the plumbing going and destroy the electricity in the home, and let's say it's a $500,000 home to $1.5 million home, who's going to pay the damages? The owner should be required to pay for the damages. The owner should be required to pay for the damages of the neighbors and any other damages that may accrue from the tenants. And then the onus is on the owner of the property to pursue what would be tenants to defendants in other states, which is very, very difficult to do. So I want to make sure that we are all covered and we all get paid our damages when things go sideways. And it's a precaution, but it's a necessary precaution. There's nothing to say that this is beneficial to the city of Woodland Park. Quite to the contrary, it is not beneficial to the city of Woodland Park by having short-term rentals. I don't know how many of you in this room got hit with at least a 25% hike in property taxes, but with these businesses, and they are businesses, it doesn't matter if it's a business run in the home, it is a business. They have to be responsible and they have to make sure that their neighbors are protected. And that's another point that I want to make is the neighbors have a right to be heard. And somebody said something about, I think it was Ms. Williams, that there would be a 3 strikes rule. And if there's a 3 strikes rule, I think neighbor complaints should operate as one of the 3 strikes. We also need to ask a question. Do any planning commission members, do any city council members plan or actually own rental properties that will become short-term rentals? In that case, they must recuse themselves from this entire process because they would be making a comprehensive gain financially by owning one of these short-term rentals. And if I think Ms. Williams can advise you, we've already had circumstances with what I'll call the tiny homes, and maybe some of you will remember me from the tiny homes that I'm sorry, I just lost my place. That the tiny homes went through with nothing except for the approval of one person, and that was Sally Riley. And she's done that many, many, many times. So it never gets to the city council. And so the citizens get figuratively a gag stuffed in their mouth so they can't say anything about this. And that's wrong.
Well, we have an open forum tonight. We're giving you the opportunity to speak, and people next committee, city planning commission meeting will also have opportunity to speak in the public hearing at that time. I can go over a couple of items here. First, to clarify, now you said you're opposed to this. You're opposed to allowing them in town or regulating them?
I'm opposed to allowing them because if we don't allow them, then who cares about an ordinance? An ordinance won't be applicable. We don't have to work on changing anything that is perfectly acceptable in our ordinances, because our ordinances would have to change things right down to the definitions.
Right, and that's where we're here looking at ordinances.
Yeah, and
So-
people who come on vacation, they're not themselves. They're not like they are with their, 2.7 children and a dog in the backyard.
Well, we can move on. I'd like to address some of the questions, comments you've made so far.
Thank you.
You were asking what percentage, and we're looking at a 6% currently in the ordinance for doing that. So this is a representative government, and this is not a quasi judicial. Nina stepped out, but I believe that as a legislative issue, the recusal doesn't really apply.
Yes, it does.
Well,
It does.
We'll continue, and we'll get legal counsel to make comment if she has something to say.
It is a felony for any public servant to participate in the approval of any legislation that will make them money. Now, that was my point that
Okay,
I
you
had.
made your point. I would like to continue. We've got a number of things to continue on this meeting. So
How do you know that the city of Woodland Park, the citizenry, how do you know that we want this?
that's determined by the representative government who voted people in place, and they are here to make decisions on behalf.
Do you have a
of the
copy of the packet for tonight's meeting? Did you
Yes.
get a copy? If you look at page 3, you can see the list of meetings that were held and the surveys that were taken to get input from the community.
What is the data that came out of that?
Online questionnaires were summarized and presented in a meeting to the planning commission and the city council by city staff,
Okay.
resulting in a summary. We have a presentation, a PowerPoint that was given to us that shows the breakdown of short-term rentals across the city, the percentages by zone. It also shows a number of data points for how many applications have been received in the last year, the year before, what we currently have in the term of short-term rentals licensed as businesses in Woodland Park. And so there's a PowerPoint from that meeting. It's available online as part of our materials. It looks like we had multiple meetings starting November 2021 through August 18th of this year. When we had the last joint work session, and all of that information is available online if you'd like to look it up.
I will definitely look it up, but considering that this affects people in their homes, in the privacy of their neighborhoods, where they have a reasonable expectation of.
And I
being
will tell
able-
you that we have received comments to that exact referral
Then-
from some of the comments that were made in the meetings and in the surveys, as well as others who are in the short-term rental business, talking about how that works for them and works in the city and doesn't create problems in their neighborhoods. So
Well, as you
like you
folks
said,
know
there's
by,
multiple comments and we've received
Okay.
both from all spectrums.
and, it would be interesting to see how many you've actually received, because when we
Hundreds,
look at
hundreds,
something as
hundreds.
simple, what you guys are all appointed, so you guys really don't count in
Well,
terms
then-
of being
Then-
elected.
then
We
sit
don't
down.
need- I think we're
pissing
done
me
with the
off.
discussion tonight, and we need to move on. So I do appreciate your input.
This is going to hurt the community, and we are going to become a suburb. Instead of being a beautiful little mountain community, we're going to be a suburb of Colorado Springs. And that's what's been happening for the last 10 years. And I'd like to say I won't stand for it, but you people are the only ones that have power to stop it. And
Oh,
I
you
ask
just
you to
said we
stop
didn't
it.
count.
And honestly, ma'am, if I can offer this,
Yes,
I was in that November meeting when someone out of the audience, just like you, came up and said, this is an issue. It's been going on. We know it's been going on. No one asked. They just started doing it. So we were then asked, hey, help us. Help us get something behind us. Help us get some ordinance. Help us get ahead of it so that we're not playing defense, we're playing offense now. Because it's happening and they didn't ask.
well, they've been breaking the law then, so I don't give them any credence
Well, if it's
whatsoever.
not an ordinance, it's not in the law, then they're not breaking anything. That's
If
their
it's
problem.
not permitted, then they are going against the city
Can-
code.
Possibly,
Yeah.
that's what we're working on.
Because the city code says what's permitted, and outside of the city code, outside of the
Ma'am,
four corners.
I think you've had the opportunity to express your opinion. We have a good feeling for where you stand and objectives are, and we'd like to continue with the meeting. So,
Thank you.
Thank you. Anybody else in the audience care to bring comment? Yes, please come forward. Give us your name and address. Care to, please?
My name is Jerry Penland. I live on Masters Drive here in Woodland Park. The first thing is that this working session is premature. First time I got the chance to look at the ordinance was tonight, sitting here for a few minutes. We should have had a week or so to look at it before we even had this meeting. So this should be a reset to give us a chance to really look at it. A question was asked, what's broken? That question was one of the first questions asked after I gave a presentation over a year ago, bringing this problem to the Planning Commission. One of the first questions asked by City Council, what's broken? It only takes 30 minutes to do a search to find out what's broken. You want to know what's broken in my neighborhood? I live in a planned unit development approved by the City of Woodland Park. That approval did not include allowing lodging businesses in my PUD. It was approved for single family residences only. No businesses, no lodging businesses. I live in a covenant protected area. Our covenants do not allow lodging businesses in our protected area. Many Woodland Park citizens live in residential neighborhoods. Our city municipal code clearly does not allow lodging businesses in our residential neighborhoods. That's why you're changing the municipal code, because they're not allowed. What I see you doing in the last year was simply trying to figure out a way to work the municipal code so that it justifies what you've been doing. By almost 200 now, there was only 100 a year ago. Now there's 200. Short-term rentals licensed by the city. What this municipal code, what this new code will do, it will change nothing in my lifetime. I live on a small street. We already have two. We have one that says there it can have up to 18 guests. Every weekend we have many, many people in our neighborhood. We don't have a clue who they are. That's what's happening in my neighborhood. We have another one pending. So we'll have three. In my neighborhood, my short street. I don't understand why this ordinance is written in such a way that you're favoring short-term rentals in single residences versus multiple residences. When I do a search, I've stayed at some short-term rentals. They're good, depending on where they are and what you're looking for. If it's in the downtown area, that's just fine. If it's in a commercial area, that's fine. I've stayed in them. What do I find when I do a search? I find lots and lots of condos and apartments and some single family housing. You're pushing this to our neighborhoods. And I don't understand that at all. Why are you pushing it into single family houses instead of that can sleep up to 18? Actually, there's one in Woodland Park that advertises up to 20 guests a night. 1833-110 municipal code here in Woodland Park deals with the character of our neighborhoods. Quote, uses shall not involve any activity not in character with majority of the uses in the neighborhood, unless by design, setback, nature of operation, other devices, the character of the neighborhood will be maintained. If you do a little search, it only takes 30 minutes, you'll find that one of the major problems that we have in the nation with short-term rentals, not just Colorado, not just Woodland Park, but all over the nation, is that it changes the character of our neighborhoods. You are, by our own municipal code, required to maintain the character of our neighborhoods. But that's not what you're doing with this ordinance. You are changing my neighborhood and all of the neighborhoods in Woodland Park by putting a short-term rental, a business lodging. If I wanted to live in a hotel neighborhood, I would have bought in a hotel neighborhood. I don't understand why the city considers the property rights of a short-term rental investors all the way from, if you look at the list of the ones you've already licensed, they go all the way from California to Florida and many states in between. Why are their property rights more valuable, and why do you consider them more important than my property rights and the rights of my neighbors in our neighborhoods? I don't understand that. Just because they want to earn a dollar bill in Woodland Park, their property rights are not more important than mine. We look to you to protect the character of our neighborhoods and to protect our property rights, not the property rights of an investor from Florida who doesn't care about us. We look to you to protect those rights. That's your job in the municipal code. Thank you for your time.
Thank you for your comments. Okay, anybody else? I guess we got a couple more. Please come up.
If I could apologize, I've been looking online and I could not find the packet for tonight. I guess I don't know why it fell off, but
Yeah, that's why, yeah, I don't know either. It's usually, I can specify.
but this is a work session, and if we don't come to any kind of agreement tonight, then we'll have another work session and you'll see another version of this ordinance. But I do apologize.
I'll just make a comment before we continue the public comment. A lot of the things you guys are talking about is about what we're about to talk about. We're about to start talking about this ordinance and what needs to be in it. And so you're looking at a draft that we were given to comment on and to start working on. And that's what we're planning to do tonight, is work on it. And so what you're looking at is the same thing we're looking at, and we're deciding what's the best interest to do with this. And you're giving us comment like we've already made decisions, which we haven't. We're still working on it. I know that may seem, like that's not the case, but the reality is we're working on this ordinance and to put something in place.
And I also wanted to make a comment about HOAs and covenants. Nina, is there a clause in this ordinance about covenants and HOA rules and regulations supersede the ordinance?
There isn't, because there's no necessity to do that. That's a private, something that's recorded onto the property.
Yeah, in fact, I checked my covenants a few months ago going, I didn't think we had that we had the ability to have short-term rentals in my
Right, a
particular
lot of
filing.
HOAs in Woodland Park.
There is no prohibition in my particular covenant, but if there is a violation of covenant, then an individual has the opportunity to bring a lawsuit against his neighbor for violating the covenant, as is the case with an HOA regulation.
Correct, that's why it's not in the code. It's not the city's, responsibility.
So Jerry, if you've got a covenant requirement that says,
But there is a quote in the municipal code that mentions covenants. You might want to check that out.
yeah, I thought there was as well, but
There is one.
it's an onerous process, but you can take action as an individual
I have
homeowner.
sued our neighbor
Yikes.
over a privacy fence that was an egregious violation of our covenants. It was $32,000, and we won. We got rid of the fence that should have never been put at the start. So covenants are extremely strong. I'm sorry, but what you've done, what you, the city, have done is license a business. You forced a business in our covenant protected neighborhood, but you won't support getting rid of it. You force it on us, but you won't support getting rid of it. What's wrong with that?
Thank you, Mr. Penland. Please have comments.
Good evening and thank you.
Your name, please.
My name is Patricia Stinner. I live in Woodland Park. I'm going to rework some of my notes so I don't repeat anything that's already been said. I know you've got a tight schedule tonight to get through this draft. And I appreciate, Nina, thank you for getting the drafts to us. It was not online. Neither was this posted as an STR workshop. And I actually had a handful of people that were looking forward to coming, but because it wasn't posted online to be an STR workshop, they reprioritized and they're going to be upset that they missed this. So I don't know what's happened within the city. It's not relevant to me. I'm here and I'm glad to be here. And I hope that my comments are helpful. That's my intention. But just so you know, it would be very helpful if the city website could be updated. So thank you for that. So it is curious to me. I spoke with Rob Feltz and I spoke with I think Ms. Johnson, who helped prepare the city's report that came from the community engagement meetings held one day in the city of Woodland Park. And I thought it was strange that nobody brought up the fact that many municipalities in Colorado have had STRs in their cities and they have banned them. I haven't heard the word ban. I certainly have said the word ban. I think they should be banned from our residential neighborhoods. Why? What's the root word of residential? Resident. Who stays in STRs? Non-residents, visitors, tourists, guests. And there absolutely is a market for it. I am not contesting that. But there's a reason why other municipalities, not unlike Woodland Park, have banned these STRs after they've been in existence for several years. That fact was known to the city, but they didn't include it in their summary for you, and I'm sorry that they didn't. There was no public comment allowed during the joint work sessions. That was frustrating for some of us because we thought we could contribute to the dialogue and you could have bypassed some of these work sessions if we were allowed a voice, which we weren't. So Chairman Hartsfield, thank you for allowing us to come up and speak. I have yet to hear what the Planning Commission feels are the benefits that STRs are bringing to our residential subdivisions. What are those benefits, please? Because for the life of me, I can't understand what they are. I was a certified general real estate appraiser licensed in the state of Colorado for 30 years. And I can tell you that from an appraiser's perspective and from the mortgage bankers that I have heard from, this is going to become an even bigger issue, not just for the city of Woodland Park. It's going to help eradicate and exacerbate the problem that we have with available housing for residents to live here. Do you know what this is going to do to the school budget? If you push these into our single family residences as per this chart that keeps appearing that says they're not permitted conditionally in your multifamily, but you're pushing them into the suburban residential and the urban residential, this makes no sense to me. What benefit does this bring to my neighborhood? I'd like to know. I have new neighbors that were very frightful that they were going to be buying a house. And the first thing they asked me after they closed their house last month, do we have any short-term rentals nearby? Because we kind of left Aurora to get rid of that. So please take these things in consideration. Let me go back to the school, the impact on the school budget comment that I made. When you convert a residence to a business, a lodging business, lodges don't house residents. They provide accommodation to visitors, which is wonderful, strong market for it. Where are the families going to live? Without the families, your enrollment is going to drop. What's going to happen to our school district revenues when the family populations continue to drop? We already have a little bit of a problem with enrollments. So please consider these things a little more broadly than how the STR owner operators want you to look at it with all the big tax money coming in. Another news flash, markets fluctuate. We're at the peak of a market. It will fall. Are you really going to sacrifice the integrity of our zoning, of our existing ordinances for a quick windfall? And then we'll all be burdened by the loss of the character of our neighborhoods? I don't want to see that happen. So thank you for your time. And thank you again, Mr. Hartsfield, for allowing us the opportunity to comment. I think that's very important in this process. Thank you.
Thank you. Somebody else would like to speak from the audience?
Good evening. I'm Mark Rabo, live on Paradise Circle Drive in Woodland Park. And I want to start off by just thanking you, Chairman Hartfield, and Planning Committee. It's been several years since I've been here, but I appreciate your service to our community. So thanks, all of you. I own the Microtel Inn and Suites in town and the Woodland Country Lodge in town. And I've deliberately stayed out of these meetings because it affects me income wise. And I thought, no, it's just not the place for me to come. Let's let them decide how to do it. And but I've had some issues come up and some concerns come up that I thought were important for at least consideration. When I built the Microtel, it was mandated that ownership and general managers went to New Jersey to go to training with the Wyndham Group. And Wyndham owns 23 different flags or different hotel flags, over 9,000 rooms. And an important part of that training was in the area of human trafficking. And before I went to that training 3 years ago, yeah, I'd heard of human trafficking, but I always looked at it as being something that happened in third world countries. After the training, I thought, well, that's interesting. And I did learn a lot. But I thought, well, that's New York, Detroit, Chicago, not little Woodland Park. And all of my employees at the Microtel have done a tutorial on how to identify human trafficking. And so it's been an interesting learning experience. And I'm now having my employees at the Country Lodge go through that same tutorial for them to learn it. But I've had some issues come up recently where we have been calling the police because we feel we've potentially have seen human trafficking happening in our little community of 8,000 people. And we have very good communication with our police department. But you go to either of those two hotels, and to get in there, especially during the night hours, you have to go through the front door because the other perimeter doors are locked or you need a key card to go in there. And we're staffed 24 hours a day, 7 days a week with front counter staff, and they're seeing the people as they enter the building and seeing stuff. It could be a drug issue, it could be a potential human trafficking issue, but my people are seeing that and they've been trained on how to try and identify it. And we don't get involved in it. As we identify something, our immediate response is to call the authorities because they know how to handle it. But I don't know if it can be an issue in a single family home. It seems like it'd be a whole lot easier to do it there than it would be to do it in our properties. But I do see it coming. I see it happening, whether it's been happening all along or whether I'm just starting to notice it because I've been trained. I don't know, but I think it should be an area of consideration. Thank you.
Well, I have a question. I've gone through human trafficking training for a number of years in my previous employment with the federal government. Why would you think a short-term rental would be more prone to human trafficking as a rule vice a long-term rental?
I think both can be prone to human trafficking. It could be a same way with the drugs. I have a good friend that built a Microtel down in the Springs the same time I was building, and we've become good friends and we go to lunch monthly. We just ran into a situation and it was not a very long term, but he had a guest that was cooking meth in one of his hotel rooms, totally trashed the room. He had to take it out of service. It'll probably cost him $10,000, $15,000 to ever rent that room out again. But that happens, and it can happen fairly quick. They won't necessarily stay long-term because as they get exposed, they're moving around as quick as they can. So it's, you think you have a mother coming in to book a room, a 40-something mother, and she's with her 15-something son, booking a room. And you're just assuming it's mother and son, but it very well could be trafficker and a trafficked child. And that's going on.
I think you describe a very disturbing scenario, but changing course, my question to you as a hotel owner, do you see short-term rentals as a competition to your business?
Well, I see that, and I don't mind the competition. Hopefully, we're all on the same playing field. If we're all charging the same 14% tax and everybody's on the same rules, I don't have a problem with that at all. And that's why I haven't come to these meetings, because I don't want to get into the economics so much. But does it have an effect? Well, certainly it does have an effect. But I do think the potential trafficking can go under the radar then, easier than it can through a hotel. I think with short-term rentals, it can be under the radar and people can get away with it longer and maybe move from one address. It could all be up in Woodland Park and move from one address to another address. I think the whole scenario is sick.
Yeah.
But obviously we've got people that deal with that.
Thank you.
Thank you.
Thank you. Okay, now we're into this a little longer than I thought, but, oh, excuse me. Yes, please. I guess we possibly have some online participants as well.
So Mike Nakai, Woodland Park. Thank you for letting me speak. First off, I don't envy you. You guys have been put between a rock and a hard place. I'm not sure how we got here. I believe, I understand that we, in a desire to capture some lodging tax revenue, we started issuing licenses. And then someone realized that that was in direct violation of the municipal code, in particular 180909, the use table, which, as far as I can see, allows no lodging whatsoever in our residential zones. So it was, it's been thrust upon you to fix that. So this is I don't, like I said, I don't envy you. One question I wanted to get clarified, if possible, from Nina, you mentioned at the beginning about a clarification of whether the entire, if you only rent it out on a short-term basis, part of your structure, then that is excluded from this ordinance. Is that what you?
Yes, from this version, yeah. We
Okay.
amended it from the
Okay.
prior version, but it's
So-
obviously up to,
Okay, then that's fine. I just wanted to caution you. I am familiar with two specific STRs, one of which basically put a bolt, a deadbolt on the door between the basement and the upper, and they are two separate, right? Okay, and where, for instance, like the owner lives upstairs and then rents out the basement on an STR basis. And so I don't know whether that's a loophole for you or not, just food for thought, okay?
Thank you.
On the topic that I think Maria brought up about public comment, I'm going to say I am actually disappointed on where we are and with this particular ordinance and the lack of public comment. Many of you sat with me for a year. We had a ordinance 1383 to draft new ordinance on single family usages and multifamily zones. We had a 1-year moratorium, and we had in this room, I don't know, 8 to 10 work sessions with the public that at least 3 of you on this dais now participated in, and I believe Jerry was on commission at that time. So I am a little disappointed with where we are at this point on how much public comment you've actually had. The events at the UPass Culture Center were very scripted, very structured in kind of how they were held, as opposed to just, like this, open public comment. But again, it's much easier from this side of the dais than your side. There's a lot of weight on your shoulders. When we adopt zoning, I assume when you approach this problem, you would take the use table, which is clearly our most protected zones on the left and our most heavily industrial disruptive zones on the right. I'm not going to talk about PUD because that was added to the table in a special item. Okay, so we have our most disruptive on the right and our most protected on the left. And so when I saw in here the current table that you're proposing, I call it a donut hole. We've got, PC on the left, 2 zones, and then all of the MF zones is blank, banned, and then essentially back in on the neighborhood commercial and up. I was a bit surprised at that. I would assume that you would have taken the table and just picked a spot and drawn a line. And to the left is not allowed, to the right is allowed. I was surprised at the donut hole. I understand the reason for the donut hole, I believe, is that we did not want to impact our affordable housing. So that was the main thrust behind the donut hole on the use table. I would caution you, if you haven't thought of this, of trying to legislate a temporary housing condition. Probably prior, I would be willing to bet that prior to Karis, we had a healthy rental availability and affordable housing ratio. Maybe we had 3 to 8% vacancy. Okay. But as you know, that Karis is a big organization and staff and students can suck a lot of that up. And all of a sudden, once you're at 100%, now it's game on. Okay. And this stuff goes sky high. But council took action last month and hopefully we're on a path to alleviate that. Okay. So I just want to caution you about taking permanent legislative action to solve a temporary housing imbalance is all. Okay. So that's all I had. Thank you.
Thank you. Anybody else care to speak?
I did want to comment on something Mike said that, Mike, we can take as long as we need on this ordinance. We've got a draft to work with now. One thing that's hanging over our head, though, is the council's moratorium. And we'll just have to deal with that. But yeah, there's no reason to rush this, except the longer we take, the more short-term rentals are going to operate without any licensing or any regulation. It's going to happen.
Yeah. One quick point on that. If I understood the math, we are at 5.9% right now. Okay. And we are proposing a 6% cap. So if we put this ordinance in place on schedule by the time the moratorium ends, we're still not going to issue any new licenses.
Mm-hmm.
Right. So at the end of the day, the effect, if you extended the moratorium till the end of the year to give you guys more time to get this, that you're all confident about getting it right, nothing will change because we're capped out as soon as you put this in place. But we have to get this done before next year when new licenses come up. Right. So anyway, that's my only point on that.
That's another dangling sword. You're right.
Okay, David, do we have anybody online who'd like to speak? Raised hands? Anybody online wishing to make comment at this point? All right, thank you. A lot of issues. I think I'd like to get into the details of the ordinance and see what we agree with, what we don't. there's any changes necessary. I guess the first part, there's all the whereases and the conditions of why this is appropriate. Any comments on that portion of the ordinance? I think they're more into- My comments are all on the more substantive portion after that.
I have one generic question. There have been references to the usage code in 180909 that I know one of the council members cited as the reason that short-term rentals are illegal by use. Nina, could you explain that? I've never understood that interpretation. And if so, if we do approve an ordinance with any type of regulation, do we need to amend that in the usage table?
So yeah, I think Councilmember Connors brought that up a lot. I'm gonna pull up the usage table on the code itself to kind of, commercial lodging is prohibited in, and obviously you all know, but anything not in the boxes under each zoning district is prohibited. So commercial lodging is prohibited in the some residential zones. That being said, we have been issuing business licenses and receiving lodging tax. I do not think in any way, because I've been asked this many times, that means it's a grandfathered use. However, this is why we're here to be more clear. You're not the
Short-term rental wasn't defined in our thing. It was all lodging.
But commercial
bed and
lodging is.
breakfast, commercial lodging, all of those hotels, motels, inns are all defined, but the term short-term rental does not appear in the definitions.
Correct, but if you look at lodges and inns, the definition,
Yeah.
it
And so
very,
that would be saying, that's where he says it's prohibited because it falls under lodgings and inns. That's
and
the
then if
only thing
something
we
is not in
reference.
the table, it's not permitted, if the use is on the, as well.
Yeah.
But more the commercial lodging, hotels, motels, I would say short-term rentals fall under that. But here, we are in
Right.
this, we're in this great situation right now because of the business licenses that were given and
Yep.
lodging tax licensing.
Well, and
My interpretation of that had always been commercial,
Correct.
part of
commercial.
it, excuse me, this is Karen. Part of what I would like to add is where short-term rentals have been so challenging for so many communities is many of them, like Woodland Park, do not regulate rental periods of residential dwelling units for any length of time. I've actually worked in a community that did, but that was back east where they had a very dense urban housing stock. So that was largely related to licensing for fire prevention purposes. But Woodland Park, like many other places, we don't regulate whether or not something's being rented for 6 months or 12 months when it comes to whether it's an apartment or a single family home. So short-term rentals were kind of a weird little twist on that, where somebody was like renting it out for a weekend.
So yeah, thanks, Karen. That's why in the current ordinance, we say it's under 30 days.
I don't have any comments in that first page either, Ken, down through till chapter 5.22 on the definitions. So all the whereases are good with me.
I'll just comment on something that Nina just said too, and that's why I brought this up at the very beginning, is that sure, we have issued business licenses for short-term rentals, but in no way does that vest that right as a land use.
Correct.
At this time.
Correct.
So I think we should take the look at it as being, this is a new use that we want to really regulate or not.
And how?
Is that a rhetorical question?
Yeah, it is. It is.
Well, I mean, if we say no, then we go home. But if we say yes, we want to acknowledge that that is a property right of many owners, then we go ahead and proceed with this ordinance.
As let's go through this and then we can
Yep.
decide if we recommend approval or I guess at next meeting. But hopefully, from my perspective, we all want to craft the best that's appropriate. And then the big question is yes or no. And that could be something to address at our next meeting. So no comments on page 1 otherwise? Going to page 2, definitions.
So I have a suggestion that for under short-term rental unit means a residential dwelling unit that is rented or used for furnished lodging accommodations and occupancy for any period less than 30 consecutive days, that we bulletize that as item 1. And item 2 is that it's not an owner's primary residence and not occupied by the owner. Just go ahead and exclude owner occupied from this definition of what this ordinance covers.
So now I have a question with that though, because if you're going to have some of the comments that we've had out there from being on space, so that you don't have someone shutting a door and they're ringing out.
Could people speak up, please?
Versus, you know, sorry. I talk very loud anyway. I thought everybody had me. So no, I wanted to bring up part of your comment, you know, that maybe if you lock a door and you're renting out 1,000 square feet in the basement versus, you know, 200 square foot room, should there be some definition there? That was part of my.
You know,
this is some-
our code does address ADUs.
Right, and so
and
residential.
ADUs can only be occupied by a family member. So that's the mother-in-law suite.
Okay.
So we're talking about an entire facility, and I don't know if we need to find a more clear definition of that.
Can I just make a clarification, like procedurally, Mr. Chair? If somebody's making a comment, it just particularly this one is on the floor, that's a huge change and deviation. So I want to make sure it's like either a majority of you all are going that route, or because to not regulate them at all, if they're owner occupied, that's definitely not what
I don't think we've
council wants.
completed our
But if
discussion,
you change the definition,
But
it is.
I think we can work towards a consensus, or at least
Yeah.
an opinion.
You just so I have direction, because perfect.
So as a work session, I think we need to get the ideas on the table.
I mean, you
Oh,
already
yeah,
took,
to amend it.
you already took out that other phrase on that.
Yeah,
I was
yeah.
just thinking,
Yeah.
did we want to make it clear or not? I was just
I'm-
proposing that as
I'm-
an option.
It's not clear to me that the change in the definition of short-term rental unit by eliminating a portion thereof really results in the effects suggested. If a short-term rental, as written, a short-term rental unit means a residential unit that is rented or used for furnishing lodging accommodations for any period shorter than 30 days. If 1 room or 2 room or 3 rooms in there are rented out on a short-term basis, then that's still a short-term rental unit, even though it's only a portion. Because that means the rental, that means the unit was used for lodging accommodations of less than 30 days. So I don't see taking out or a portion thereof changes its meaning significantly.
Yeah, that's why I was proposing that added language.
And yeah, and if you could try that again, Ken, to see what, I'm not sure, I didn't follow exactly what you're doing. I'm not disagreeing. I just didn't, sorry.
Just adding a clarifying statement for a definition of a short-term rental that we're not talking about, that it's not an owner's primary residence where they live, and it's not occupied by the owner.
But there's a big difference between what was brought up with Councilmember Zulaga when it's
And
just a
not-
part of the house. So I want to say that it's when it's the whole house primary residence, I think they still want to make sure you regulate it. It's one thing if what Commissioner Brown was saying about, distinguishing them, maybe not including them in the caps, the buffer, but we still should, it's not.
Yeah, I understand. So there may be better language.
So basically, I understand what you're saying, to better define this or wherever it is to address that situation. That's more helpful. Okay, thanks.
But I think there are 2 issues that we're discussing. Okay. If I, as the property owner, are living in the building and I'm renting a room out, that's a different situation than I live there for 6-7 months
Correct.
and go to Florida and.
And that
come
situation, I
and
definitely
go.
want to regulate. Yeah.
So
Yeah, it has to be
I think
occupied by
as-
the owner.
owner occupied, in my mind, should be the owner is present while the tenants, the renters are also in the buildings.
That's
I
why I
think
said
that's a
it's their
little-
primary residence where they do their tax return, their address, whatever
No.
that defines primary residence, and it's occupied by them.
No, but
And they're renting only a portion of their.
Yeah, there you go.
Yeah.
And they're renting only a room or,
I support allowing them to rent out a room while they're occupied because they have the proper supervision, know what's going on.
Yeah.
Even if it's you're living in one little room and renting the rest of the house out there, the owners are there and responsible.
Yeah.
Again, if they're out of state while they're on vacation and renting the house out.
Once we regulate.
That should be a
inclined to
short-term
opposed to
rental,
that. That should be a
because
short-term
A
rental.
lot of vacation homes that people own here are gonna wind up in this short-term rental bucket because they don't live here permanently. It's their vacation home. They're gonna want some income off of it if it's available to them, potentially.
Yes.
So I agree that, but so I was trying to just add the words to make it that it's where they live, and
And only the
partial,
room.
and only partial.
I understand.
Yeah,
I mean, I
okay.
just want to make
And
that
exclude
situation more
that.
clear.
Is it,
Exactly.
is
That's
it clear to
not-
everybody that this is readily enforceable? I'm trying to understand what it means as the owner is present. If, I mean, the owner obviously can go down to the grocery store while the group is here. Can they not stay out overnight, overnight for a concert when they went to in Denver? Or
No, no, no.
what
It's
about if
just-
they're
Renting a
gone? Or
room versus the whole house. I understand.
It's just where they live, and they live there, and it's where they.
No,
occupy.
but we're trying to make a distinction here.
Yeah.
It's, at least it sounds like, whether, and Ken used a good example, the ones, the snowbirds leave for 2 or 3 months and rent out a series of short-term rentals while they're gone.
Mhm.
As that becomes shorter periods, it becomes very hard to distinguish that between that from, whether somebody is present or not present.
It's the portion, I think you want to address the situation that we're speaking about
Yeah.
better with, there's two different situations. One
Yep.
is what Commissioner Brown brought up earlier, and then you're talking about just when it's the room. So I understand, I try to make more clear the renting of the room. So I understand what you're.
Thank you. Nina.
Okay, do you understand? Say, I don't understand what we're trying to agree upon or not agree upon.
We want the person who's renting a room in their house to not be considered a short-term rental under this ordinance.
Okay, and we can distinguish that readily from somebody who, if I go away for, if I go for 2 weeks to Florida and rent it out, we can distinguish that readily without having the,
Nina's gonna put language together for us to that.
I feel like we'd
and-
have to look at the level of intent.
Yeah, and it is, when you look at the listing, you could see which is if they're just renting the room versus the whole house.
And I agree with Lee that the purpose in any of this is to make sure it's enforceable and it's simple to understand. If we get so many nuances in of, I'm renting my closet space out to the neighbor who's got Christmas decorations, yeah, we don't need to go to that level of detail at all.
I would suggest we just keep that definition the way it's worded is acceptable to me.
I would prefer to see the clarification just to make it more clear, but because I think it leaves it too open.
For the renting of the room.
Yeah.
And then it's a different policy question when you get to it, where Commissioner Brown brought up, should the primary residence be treated differently for the cap and the buffer? I understand. I'm hearing you.
Anything else on definitions?
So what do we decide?
isn't this also a question? It's not just it's a rental of a single room, but if it is its owner, if it's owner occupied. So it seems to me you need a definition of what somebody's primary residence is. And an owner occupied short-term rental is a short-term rental unit, which is the primary residence of the applicant.
I think there's legal definition for
I've-
primary residence
Yes,
in
I've-
the books on lots of different.
Yeah. I've
Sure,
really-
sure, exactly, but an owner occupied short-term rental is a short-term rental, which is the primary residence of the applicant. However, primary residence is defined.
I think Nina has.
I hear you all.
directions.
Yeah.
She's
If I need
comfortable with that.
clarification on this, I hear you all. I take direct, yeah, here.
So Larry is got a slightly different opinion. Lee and I think are aligned on the modified language that we'd like to see. We probably need to get the opinion of Carol, Ken, and Sean to know which.
I'd support the modification.
Me too.
Yeah,
Okay.
Yeah, and clarity being the objective.
Yes.
Absolutely.
Excuse
Licensing,
me.
yes.
From a staff perspective, what I'm not clear on is whether or not the owner needs to be on site whenever they are renting out a portion of their property.
No.
Yeah, yes, because otherwise they're renting the whole place.
Right.
Now, they own the property, they live there. And I don't think it would have to be up to us to regulate whether they're there the day that whoever they rent the room out to shows up. How could we do that?
Well, that was kind of why I was checking. And now the other scenario that I want to kind of throw out is it's my primary residence. It's the one I use for tax purposes. I'm there 185 days out of the year. 175 consecutive days, I go off to Arizona. And during that time period, I've got a management company that handles STRs of my property.
That should
And
be an
I,
STR that's
Right, and that's not
licensed
renting the
under
whole room,
ordinance.
because if you're not there, you're not renting just the room, you're renting the whole house. And
but
it will reflect
I've
on your
roped
rent.
off a portion of my house that I don't want other people in, that it's all secure. So there is actually only a portion of the property that is rented out
Yeah,
during.
you're
the
not
time period.
occupying that house. It's unoccupied and it's being rented as a short-term rental. It's just your primary residence. but
She
you're-
draws a, she
You also
draws a
have to
good
be
situation.
occupying that home, I think. If you're gone for a day on a trip, that's one thing, but if you're gone half the year, it should be a short-term
Because it'll be
rental.
reflected in the listing. The listing will say the whole house usually, but we
Karen,
can,
Karen makes a good point, because you don't always rent the whole house. You may have your master bedroom locked up because, and the rest of the house is available for rental.
Yeah, I think
But we're
the
saying a
situation
room.
she referenced.
Distinguishing, it does seem to me that there's going to be some enforcement issues of trying to figure out how long can somebody be out of the house during the time it's rented? What are we talking about?
because you're only renting a room, and it'll be clear in the listing that it's just renting of the room versus the kitchen is available and that sort of thing. But obviously, you guys can decide which way you go on it.
Yeah, that's a vacation home scenario, which I think should be a short-term rental.
Yeah,
and
I
governed under the
think
ordinance.
the scenario that Councilman Zuluaga was considering is someone who was just renting a room and maybe a
Just a
bathroom
room.
and not even on a short-term basis.
Any kind of basis.
Yeah,
I understand.
but I mean, we're already arguing over that, so how do we make that clear that we're not talking about that situation? We're talking about,
That's what you're trying to exclude. You're trying to exclude that situation, renting of a
Right.
room.
Yeah.
And I hear you guys clearly, unless it's.
So that's what we need, Nina.
Yeah, that's what I'm here for. Don't worry about the words. Like, tell me what you want to happen and I'll make it happen.
Just, yeah,
I
make, make that one bedroom in my home where I'm living, not be part of this short-term rental regulation. But if it's a vacation home or a home that's unoccupied multiple times during the year, it's being rented out, it needs to be under short-term rental regulations, licensed and authorized by ordinance.
and I think you need to cross-reference ADUs and their exclusion.
Right, because that's a separate housing unit. A room is a room. So yeah, we're like a boarding room. So it's like, we'll separately, to your point, that's helpful, separately define a boarding room versus an ADU is an actual housing unit, as you know, you're bringing it up, to make it clear.
Move on to.
Thank you, Ken.
Thanks. Licensing limitations and requirements, bottom of page 2. Any comments there? I think D3 has the reference to Teller County.
Yeah, I was proposing that that be struck.
Yes.
And whose registered agent, natural person controlling the corporate ownership resides in Teller County, that we just put the period after their
Business.
business in the registered with the Colorado Secretary of State to conduct business in the state of Colorado, period.
Yeah, that's what I had at first. And I do think that's enough to address the situation where many of you are concerned about is that large corporations coming in. It's probably not going to happen. This is for like LLCs and that sort of thing that are in.
Yeah, and I noticed that Rob Phelps is online.
Oh, wow.
Several months ago, Rob had, and I don't know if it was ever updated or not, had listed the addresses of the short-term rentals that had licenses. It listed the name of the applicant and it listed their permanent address. And out of that number of, at that time, I think it was 156, I think there were less than 10 that were individuals that lived out of state. So I understand the concern. I mean, I have people in my neighborhood who don't live in this state and they have every right to do whatever they want to with their property under the law. But I wouldn't tell them, well, you don't live in Teller County. You can't rent your house out.
Yes, and I had that to begin with, so I think I'm gonna just delete it right now.
I don't think the clause Teller County does what it was intended to do to prevent corporate ownership, because,
No.
having a registered owner. an
All you have
agent
to do
in
is get
town-
somebody and say, I'll give you $10 to be my registered business in Teller County. It's easily defeated and it just is pointless. We're not going to enforce or be able to enforce it most likely.
But I'm keeping the business entity, yada, yada, until Colorado, and then taking away the.
Yep. Like the rest.
Agree with that. Any other comments on this page?
Yes.
A small item in paragraph D, it refers to listing the business license number. I assume there's a number on the short-term rental unit licensing, and that's probably not the business license number.
Yeah, that's a good point, Lee.
The
because I-
short-term rental business, yeah, so I'll just change it now, short-term rental business license.
Yeah, enter the,
And
insert
Par-
the word
par-
unit between rental and license.
We don't need unit, but it could be short-term rental business license number.
exactly. Paragraph F,
I have another comment on D, Lee, before we move on.
okay, sure.
I got comments too.
I was just going to suggest that it be just that it should be listed in the listing for all public advertising and not the title of the listing. Not that, just because I'm thinking that some of these listing companies will have a location for it and may not allow it in the title. I don't know. But it should be listed in the advertising somewhere.
A
But-
lot of places, cities and towns require this only because it's easier for staff to enforce. It's
Yeah,
right there in
okay.
the number, but it's right there in the title. It doesn't have to be, but that's for the reason, and there is room, but it's up to you all.
I just thought that was going to be a little bit problematic for us to try and enforce that
No,
portion.
it's actually easier to enforce because you can see it right in the title, and the staff doesn't have to like go in.
I just was
You might
wondering, what
also,
if
you might
Airbnb
also
says you can't
delete-
put that in there
They haven't
tomorrow?
with any of the other cities and towns that have this exact same provision.
So we got plenty of cities that'll keep
Yeah.
it going.
Yeah.
That's fine.
we
then.
might also
I just
delete
wanted to
the
question it because I
Name-
thought
Please
that might
do,
be
I'm
a
not trying to
problem.
argue, I'm just trying to explain.
No,
Please.
Lee?
Yeah, I was gonna say, we might also delete the names of the various web hosting. Those will change over time, and I hate listing commercial companies advertising in our ordinance who they are.
That's fine.
Just in that at web hosting services.
That's
Period.
Just, yeah, exactly.
that's probably the best.
Such as, and,
I just deleted it.
So it says all public
Such as-
advertising, comma, so the such as can just be deleted, yeah. I'm okay with that.
Yeah, if we're finished with D, I was going, F,
Go ahead.
F omits reference to the trust situation where the applicant is the beneficiary of a trust for the house. The situation is described earlier in applicant, but it's omitted here.
Okay, I'll put that, add that, thanks, Lee.
I'm going back up to A. This is a good example where we talk about in the first sentence procuring a license. And again, we're talking about two different licenses. One is for the running of the business and the other one is running or the separate unit. So we have to be very clear which license we're talking about at any one time.
Yeah, I just want to make sure that we're clear. So this is good to talk about. So chapter 522 is just about short-term rental licenses. And the short-term rental unit definition is just to explain what the unit is. So this is all, anything within this chapter 522 is about a short-term rental business license.
So there was some question I had about this as well.
Okay.
Just to make it clear,
Yeah.
when a person applies for a short-term rental business license in Woodland Park, it's by address or by unit, correct? So
Yes.
there's only one license. It's a license for a unit
Correct.
that's in a person's name who has to be the property owner.
Yes.
That's what we're doing.
Yes.
And then, so there won't be a business license to be a short-term rental business that has 12 units. There'll just be 12 licenses,
Correct.
one per unit.
And and the
So
owner
every
has to be.
reference to license here is the unit license.
Yeah, because it's in the chapter 522 short-term rentals.
Yeah, so we're only licensing units, not a business, a group of units. We're not doing that.
There are other provisions in this code that kind of relate to either a business or a unit. And I'm just
It
saying.
needs to be clear.
I'll make
needs
it
to
more
be clear.
clear to be consistent, so don't worry about that.
Yeah,
I'll give you my detailed comments
Yeah.
because I address all those.
Oh, that'd be great. Yeah.
Okay,
good.
but it doesn't really.
I had the same question. I just was thinking it's got to be the unit because the way we've written so much of this is towards the unit.
I thought that way at first, but
Yeah.
some
then
are
I-
very
yeah.
obvious. as a
So if someone
business.
were to have
Good point.
three
Okay.
units, it would be
Three
three
separate
separate licenses.
Licenses.
Right,
one
and the
person.
owner needs to be the
Business
applicant.
license.
That's for,
Unit license.
you know, accountability. That goes back to the residential character.
Currently, our business licenses authorized for short-term rentals that we've been giving out are by unit, correct? Karen,
Please, because the lodging tax is specific.
if a person has 3 properties in Woodland Park that they're using as short-term rentals, they have 3 licenses currently.
I don't
You know,
think they
I'm
have
not-
to.
I'm not sure how they've been doing that.
It's
That
been fine
the,
Department so far.
yeah, that's really been run through the finance department. And so the business license may be truly just that for the business that somebody is running.
So we need to make sure about that.
To make it more clear, because the intent is again for accountability that there's a separate application for each unit and it's the owner who applies. So again, there's accountability, not some management company. They could have a management company, but the applicant is.
Paragraph A already addresses that. If it needs to be clarified, that's fine, but it does provide, it's applying for a business with respect,
to each unit.
it says with respect to each short-term, a license with respect to each short-term rental unit.
Yeah, I read that about this. That's how I interpreted this one, but I was just curious about our current. This could change the percentage of licenses for units and stuff like that in later discussions.
B, you had a comment on F, I believe?
I made that. That was the fact that, add trustee language.
I took it, thank you.
Yes, thank you. Anything else on page 2? then?
I have this is paragraph G on page 2.
First one on the next page.
Okay,
Let's
I'm
go to
sorry.
Page 3.
All right. I have a recommendation for paragraph G. In looking at the chart from the staff's presentation and the PowerPoint, we have each residential zone, urban and suburban. We have the PUD zone, we have multifamily zones, and the number of short-term rental licenses currently in each one, and a percentage. And then we have the commercial district. Because commercial, we have discussed not regulating the quantity of short-term rentals that are going to be allowed in commercial zones. That does affect total licenses in the city, and it doesn't affect us trying to protect short-term our neighborhoods and their cohesion. So I would suggest we put a table here that has each zone listed with a percent cap for each zone. So we could have a suburban residential cap of say 4%. We could have a urban residential cap of say 15%, because our urban residential zone has probably the majority of our current, well, it has a higher percentage. The commercial district then would say no cap, because we're not going to cap that. It's market driven by what the market will bear. And those are 12, 19, and 10% already. So if you know, they're consuming a large portion of our, or some portion of our available units, but clearly suburban residential and urban residential are some of the leaders. Anyway, so that's my suggestion, is that we set a separate cap for each zone
Of the 3.
of all zones. We list in
Okay.
all the commercial, we list the multifamily. And the only reason I say we list the multifamily is because we already allowed some in there. And I don't know if we want to get into saying that the people who've recently bought townhomes and they're renting them out as short-term rentals no longer can do that. I don't think we need to allow any more. If we want to protect those, we can put a cap. But that gap allows them to continue until they decide not to do that or do something else.
And a question about that too. I've seen Ken's table. I do not disagree with it at all, because if you do look at the density of the current licenses, the large majority is in commercial or not.
There's a large density in urban and
Right.
commercial zone in Woodland Park. I don't know if they're all licensed, but when looking at some of the materials on how ordinances have been created for other areas, one was that AirDNA. if you look at the air DNA for Woodland Park, there's a high density in this downtown area of advertised, not whether they're active, licensed, I have no idea, but advertised short-term rentals. And in some regards, that's probably the best opportunity for a short-term rental business is to have it in the downtown commercial zone or right near it and not in our outer neighborhoods. If you do look in the outer neighborhoods, there's not that many. But if we are allowing a cap, it should be to protect specific zones and not necessarily penalize everybody, especially commercial where we said we weren't gonna.
So right now, I said, I said no caps shall be applicable with the commercial, but you're saying that it still is housing units, so you should have some kind of cap. So is that what you're saying? I want to make sure I hear everybody.
So I can share my screen and show you what I'm recommending if I can.
While he's doing it, going back, I mean, Ken's table does include caps for multifamily, and we talked about not allowing them in multifamily units. The definite, and I am, as long as I've lived here, I don't know what's the difference between a townhome, a duplex, and an apartment building. I think the discussion that in the survey results I saw was that people do not want someone to sublet their apartment building like in a Trail Ridge situation. Would we want to prohibit short-term rentals in a townhome development or?
Well, I think one of the basis we haven't spoken about it is the housing availability in town and how we're addressing that. I think that's why we're looking at the multifamily is perceived as being a more affordable unit. And so that our workforce housing is not impacted by the short-term rental. And I think that was one of the goals.
I think
that
you're
we're going
right.
for. It's not been.
And I think you're right, and that would certainly cover Trail Ridge, but what about the new townhomes on Baldwin right before you get to the high school? I know for a fact, a couple of those are already being rented out as short-term rentals.
And all I'm saying is put the table in, and then you can set a limit for multifamily. It could be less than what's out there today, so that when renewals come up, I'm not saying set the amount, but it's multifamily urban, I think is where those exist, is 1.77 today, and multifamily suburban is 4.64% currently. But we set it at 2%. There's nobody getting a new license in a multifamily unit. We protected that housing segment. But you've not taken away.
You could also prohibit it in apartment
Prohibit it.
buildings, even without relating to the zone district.
Well, an apartment complex has rules that would govern an apartment complex. I'm not sure that.
But that's your
Well,
workforce
it's-
housing.
Yes and no.
It's an owner, single owner for the apartment building.
Right.
Typically, it's not a condominiumized project. So if that owner wants to, and again, I
I do a lot of work out of town. I rent apartments for business. And a lot of them have a short-term apartment or two for guests. So if I'm staying there and somebody's coming, I've actually rented those. It's like a hotel room that the apartment has for, if somebody's staying at the apartment, they don't have room for a guest and their mother-in-law wants to come because they had a grandbaby or something. They have a place to rent to them for like a hotel. So I don't know if that would be covered if we're saying you can't have a short-term rental in an apartment. I don't know. But most apartment complexes have one or two rooms for a guest to stay in.
I think the intent of this was for the, just generally not to prohibit it in rental apartments. So you could still have them in multifamily zones, which I understand that includes townhomes. That's why you guys give good insight. And then still prohibit them in apartment buildings and in apartment apartments.
Yeah.
Someone's renting out their apartment. And that's different. I think I will make sure, obviously, in the code that we distinguish what an actual apartment is versus an owned condo or a townhome which you own.
So you're suggesting Trail Ridge, I'll use them as an example, is the management of Trail Ridge could designate 2 or 3 of their apartments for short-term rentals. But an individual who's entered a lease would not be allowed to sublet their apartment. I mean, that's just a question. I don't know if that's the.
again, it's what's the intent? I mean, my understanding, motivation for this whole process is to protect our lower affordable housing.
Right.
And so by allowing short-term rentals and multifamily units, we're kind of defeating that
We've negated
intent.
that
But
purpose.
I see what.
I agree, and that's why I tend to think we should prohibit them in apartments, but that was why I asked the question, do you consider a townhome or a duplex
No.
multifamily?
Yes.
Oh, you do? Well,
By,
you should-
by code
The
definition.
though.
Well, in terms of like what your direction, I want to know, like if it was an apartment building that's separate than an ownership, but definitely flush it out for, to your point, what do you actually want to, where do you want to prohibit them? If someone owns a duplex, that's different than an apartment building, but that's not to say you can't prohibit those as well.
I don't know, it's if Karen's online, if she can answer, or Dave, what is?
So what's going to happen with our seven multifamily licensed
So that's what I'm trying to
STRs?
clarify. So we could take away, now that I'm hearing you, what I hear, especially it's good that Sharon's bringing up the purpose of why I added that was more for not the multifamily zone, it was to prohibit the multifamily units, which is a rental unit, a rental apartment unit. We'll make sure the definitions are correct. That's different than a townhome or
Now,
whatnot.
the way the draft ordinance came out and the way the discussion occurred was
Yeah.
that multifamily zones, 0 was the way, and I'm recommending that we just put it in there as a cap and set the cap to not create any more because we want it to be 0. But I feel like you're going to create a can of worms if you have 11 people out there who have these licensed already and say, no more, you bought a $500,000 townhome for a
That's what I'm trying
vacation
to-
home.
that's what I'm trying to
You
say.
wanted to rent it out and now you can't do it anymore.
That's what I'm
I
trying to
mean,
distinguish
there's just 11
between
people that are going to
Right.
potentially sue
rental
us.
units
No,
versus.
no.
Well, that's the
Excuse
point.
me.
No, go ahead.
Excuse me, I asked at the very beginning, there is no vesting if you get a business license. If you got one during 2/20/22.
Right, it's just being
this
practically, I
regulation does
understand,
not
but
Bring that forward.
there's difference between.
No, we know.
Between, do you want to only prohibit them in apartment units? And there's two choices and not mutually exclusive, the multifamily zone, there's two separate. even
Well,
though
if the applicant can only be an owner, then someone who's renting an apartment would not be eligible for a license anyway. It would have to be the owner of the multifamily unit or multifamily, unit.
Right, we just like kind of double down and say prohibited in multifamily or apartment buildings, I forget how I write it. So that, it sounds like everyone's on board generally with that. Then there's another question, do you cap the multifamily zone or do you not prohibit that? So it's two separate. It's a multifamily zone versus multifamily apartments. I think I understand one, and then I think we should probably need greater direction on what you want to do with the multifamily zones, which include those townhomes and duplexes.
Well, I go back to my first question, is a townhome considered in multifamily zone? I don't remember if that's the case or not.
They are.
Yes, it is.
It is?
Yeah,
Okay.
they're
Well,
in
then,
zone multifamily.
so an owner of a townhome, are we saying that we do not want them to be able to get a short-term rental license?
But we have 7 already that do, right?
There's 7 in multifamily suburban and 4 in multifamily urban as at the time of this August 15th presentation.
In the zone, not.
In the
yeah,
multifamily
versus
urban
apartment
4,
buildings, yeah.
multifamily suburban 7. Now that's 1.77% of the multifamily urban and 4.64% of the multifamily suburban units in the current build out. So they're both below the 6% cap that we were talking about for others. We could cap those low so that there's no more. And those 11 then could just play out however they play out, or we could say 0 like we were headed and they just don't get to renew. And we deal with what those property owners' concerns are when they come and say, hey, I bought this and I've been renting it out. They may just rent it out anyway and not tell us, or they, may
Rent it
decide to
long-term.
rent out.
Well,
long
there's
term.
nothing wrong with renting it out. The question is renting it out on a short-term basis.
Right. Well, I know, it's the issue of are they buying vacation homes and they want to rent them during the other period of time? And this is the thing, if these places are being bought as vacation homes rather than available housing for affordable housing, then we've kind of missed the mark on providing affordable housing. And they're not going to be available for affordable housing, whether they rent them or don't rent them. So they're going to argue that I own this. It's not going to be rented long-term because I'm going to be here in the summer for however many weeks or however many months. So that's the issue I see. By saying zero, you're going to get in a big argument with these 11 people, create a legal issue of we're discriminating against them when we let others.
Well, is there a way to allow existing to maintain, and that's kind of a grandfather situation?
Yeah, I don't want to say grandfather. I would rather just have a low cap. I know you can hurry it up.
Can we?
Well, that's what I was thinking, just have a cap.
And it's more give policy direction, like flush it out, like why would you allow some short-term rentals in single family, but not in townhomes? I understand. I think we're clear about apartment buildings, but just flush out policy direction. Do you want there to be a low cap on those townhomes because you're allowing a low cap in single family or not? Just.
I think if we're trying to say we're managing the available housing in Woodland Park, then we set caps to limit how much can be consumed by short-term rentals. That's all I'm saying is we can set the cap at whatever. I just think we should just set a cap rather than say zero. And then,
I think zero is the goal I'd like to see.
and it could go that way.
The transition is what confuses me.
Can we say moving down to 0? And so not necessarily that we're gonna not renew,
Well, I
but
think we
just
set the
that-
table and then the table can be revised over time.
but just that like if somebody were to sell a home, well, guess what? You've now sold this townhome. You don't get to reuse this license in another home that you bought. This one's kind of gone. And we'll just kind of move our way down.
It'll trip naturally, but
Right.
Yeah.
yeah, I'm definitely in favor of prohibiting them in apartment buildings.
clear.
And-
Yeah,
But
yeah.
just want to be able to legally make that distinction in multifamily.
Because apartment units are rented.
Mhm.
They're not owned. And it's a building with,
Yeah, I don't see how
They would
somebody
not
could
be
run a
able to
short-term
apply.
rental business
They
out of
wouldn't
an
be able to apply.
apartment.
but it's good to clarify that. I agree.
Okay,
I agree.
excuse me. Excuse me. In looking at our larger use table, townhomes and apartments, multifamily dwelling units, those require a conditional use permit in the multifamily zone district. They are not permitted in the single family, the suburban residential or the urban residential. Where it gets tricky, gets us back into the planned unit developments, since those particular zones can have apartments, they can have townhomes, they can have single family dwellings, all within that PUD zone district. So that's where it's a little dicier.
That's why we're saying, thank you, Karen. That's why we're saying prohibit, I hear that we want to still prohibit them in apartment buildings. And then I had a 6% cap in the PUD zoning district, similar to the single family residential.
I agree with Ken's table. I think that's a very good idea. And it kind of gives defined by.
Gives you granularity in how you manage each zone.
Right.
Even the PUD at 3.24% as of August 15th could be set at 3.3% or 2.3%. And that manages PUD growth and future STRs in those zones. It just gives you the flexibility. Okay, anyway, that's my recommendation, is that we make it granular. Then we can talk about what's the appropriate value for each zone based on our current numbers.
It can also be a discussion when the PUD comes up for approval. It can be a condition, you will not have short-term rentals in this PUD, multifamily. I mean, I don't know. if-
Well, that's why I will say no apartments anywhere, but then the PUD should be capped and then maybe make that very specific in the PUD language.
On apartments.
Yeah,
Yeah.
no, not apartments, just no apartments.
Yeah, okay.
For short-term rentals.
So can I ask, just so I just want to make sure I'm understanding, when you're saying 4%, right? Are you talking the total population of 4?
No, I'm
or an
talking that
individual 4%.
every zone should have a percent cap set based on our intent of how to manage that zone.
Right.
And
But
I
I'm
think we've
saying
all
over-
agreed,
I'm saying
commercial, we're not
overall.
going to limit businesses from growing in a commercial zone.
Which I agree.
So I
So
said
no
no
limit,
caps.
no limit, no limit.
I already have said no caps. in this.
And then, yeah, and then multifamily zones, we would also have a limit. Residential, urban, suburban residential, planned unit development. all the others, we would have our
Right.
limit. And we can even set a limit for the commercial district if we want to, so it doesn't become all condos or whatever.
No, I'm just asking if your limit covers all of, Woodland Park, or are you talking of an
Each
individual?
district, it sounds like.
It covers all the suburban residential zones in Woodland Park.
So.
It covers all the
of us
urban
could have
residential. It's by
one.
zone.
Okay, no, I'm just asking for.
Yep.
I just want to make sure I'm
So
following.
it would be 8% for a zoned area,
Right,
which is highlighted in our zoning map.
okay,
And all those zones then would be capped at that amount. And that would allow us to say, we've got enough in suburban,
Right.
no more.
Right.
Or we want less, so next go around, they'll be reduced
okay.
by whatever cap is set. Or urban residential, we say, okay, that's not where our problem lies. And a lot of people are building those old homes in the downtown area into short-term rentals. Maybe we better a little bit more forgiving there and let some growth happen there, or not.
Right.
Just whatever's needs to be done.
Proposing setting a percentage by each zoning district.
Correct.
Exactly,
Right.
just in a table
So
by zone district, so that each one is managed
I
individually.
have questions about how much in each zone, but. if
Still need to
it's-
find that out.
Similar to the water department, asking council to review water taps annually. This may be a planning department annual review that's presented to the planning commission and city council.
We could set that annually and then they would know if people can get licenses or not, depending on. But it helps answer and address each zone separately. If we put a cap on the whole city, then what do you do about the commercial properties? We got to take those out. That changes our percentage.
Well, right now I
Number,
had
it's
no
not
caps on
6%, it's-
commercial districts here, but
Yeah.
I heard.
No, I just wanted some clarification. I just wanted to make sure I was following
Yeah.
along. I got you.
Okay, I understand.
Anyway, that was just one I saw that I think would help
I
in our
understand.
management of this.
I mentioned earlier about the planning department taking care of the short-term rental unit inventory.
Yeah, I had that. I couldn't.
This would be the place to do that.
I had it in the section. I think I deleted it. I had, because I do something similar in Fair Play. Where it says there's a waiting list and then that the list is held with the planning department or city clerk, wherever, it is, but in this case, the planning department.
Yeah, the waiting list is actually in the next section.
Section H.
Oh, I do say it here, Larry. In G, a running tally of which will be kept in the city planning department office and open and available for public inspection during business hours.
So I was going to leave that.
So is that what
paragraph,
you?
just take the cap part out of the first part of G and
No, I
put the
hear you.
table in?
But Larry, does this address
And
what
say a
you're,
running
what's already
tally
there?
of, I was gonna call it residential dwelling units within the zones, allowing short-term rentals will be kept in the city planning department. But it's the same. We just need to keep a tally by zone of residential units. So that we can,
Yeah, and
get
the
the
cap
right
should be in the
percentage.
code for that purpose, but I just want to make sure, Larry, that do you feel that that does address what you're trying to say, where I have it in that first sentence, the running tally, which should be kept?
Yeah.
Well, a running tally, by zone,
Yeah, okay.
yeah,
Perfect.
that's fine. And certainly a running tally of total is also
Yeah,
important.
and that is addressed in G.
That's what I was trying to see, make sure I think I
Yeah.
see it there. Just make
Yeah,
sure.
I just try to clarify that a little bit.
Okay,
but the sentences about caps should just be covered by the table about caps
Gotcha.
for all the zones.
within this section. I know what you mean.
And is there any, help me with this, but public, semi-public land, I'm assuming there's no issue with prohibiting short-term rentals there, but agricultural, is there any weird thing that's gonna happen with an agricultural zoned area? That's gonna have some kind of residential thing that, I know I've stayed in a farmhouse once, and I had to go to a wedding, and the only place close to the wedding venue was a Airbnb that was a farmhouse on somebody's farm. I don't know if it's, we're not gonna get anything in agriculture, we can still prohibit that, right? There's no residential units.
I would argue it's you probably want it for, if you have those ADUs for, workers, seasonal workers.
Anyway, the agricultural, public, semi-public land and heavy service, commercial, light industrial, we had prohibited. I think that stays fine. If somebody builds a bunch of residential units in one of those zones, it'd have to be
PUD
PUD of some kind, right?
or rezoned or
Yeah.
whatever. And
Very good. I just want to make sure.
Yeah, thanks.
Again, I like your idea. I like your approach. I like my district. I took the approach when I read this chapter. We need to clarify exactly what we're doing. And I think your table does that. But Nina, I'm just gonna ask you.
Yeah.
Just look at that language.
Yeah.
There, add the table and see if some of the language that I proposed, just to clarify, fits,
Perfect, thank you.
okay?
Couple small things, not disagreeing with anything there is it totally clear that when we talk about the denominator of these fractions is residential dwelling units? As I was reading it, it just sort of jumped out to me. You should probably say excluding ADUs. Because perhaps the ADU is a dwelling unit. We don't mean to double count
No,
ADUs.
I think if you go down to paragraph or
K.
section K, it says no accessory dwelling units.
Well, no, you can't put them in accessory dwelling units, but you also mean you can't count them as the denominator and getting your percentage.
Well, in
saying
terms
at
of
the end-
percentage, you don't want to count the ADUs is what.
Exactly.
Right, you want to.
Exactly. That's different than saying you can't make an ADU a short-term rental unit. The other thing, actually, it starts here. It's a bunch of places. We're kind of loose we've defined carefully short-term rental business, short-term rental units, but we now here starting in G, we start then using the term short-term rentals. And I think we mean short-term rental units. So that recurs multiple places throughout the document.
Exactly.
Pardon me, Mr. Chair, could I interject something here?
Yes.
Under in 1833.135 on accessory dwelling units, it specifically states is to encourage the creation, availability of safe, lower cost, habitable rental units and offer a way for homeowners to offset the cost of living in the area. So I just want to make that clarification on.
And I
ADUs.
feel like that's, because Karen brought that up, that's, a lot of codes have that similar language. It's more, it could be for long-term rentals, especially to give availability of houses or places for people to live for the workforce. But it's obviously a, policy decision, but I think it doesn't conflict with that section.
And then I want to pile on just briefly for something Carol said earlier. Within those our ADU regulations, it does not limit who can live there to just a family member.
Oh, really? Okay. I sort of
Yeah.
recall that from the discussion years ago.
I mean, that's typically what,
Regular single-family dwellings on it, how many people can live there with it being immediate family members?
No more
Yeah.
than 5 unrelated,
Yeah, there's no more than so many unrelated.
5, I think.
and
Yeah.
that's where the birth of the ADU comes from, was that whole concept of the mother-in-law unit. That's the phrase that
Right,
gets
a separate
kicked
house
around a
and unit.
lot. But, that's definitely morphed and is now more broadly used to help provide additional, essentially, hopefully more affordable housing options in.
Well, that-
Which is why you prohibit short-term rentals and ADUs.
So you in subparagraph K say ADUs will not be used for short-term rentals.
Mhm.
So we're not changing that concept.
Right.
Okay.
No.
I want to go back on something what Karen said just a while ago about PUDs. When a new PUD comes through the process, it's two parts. One part is changing the zone from whatever it was to a PUD. And the other one is to provide for a PUD final development plan. And that shows on that larger PUD area, what areas within that area are designated for certain uses, apartments, multifamily, single family. We should just take care and be diligent about, are you going to provide for short-term rentals within your PUD project? And that's the question we need to ask at that time.
Yeah, and then still I would still have a cap just to protect you on both ends, because things are sometimes missed in a PUD process, in case you guys have been checking out Zoom meetings.
Well, if you recall the project over in Tamarack area, we asked that question.
Yeah.
And they said, no, we will not do that, but that was by HOA. And it goes back to HOAs override this.
Of course.
If in fact the HOA is more
The
restrictive.
HOA and the neighborhood covenant should be more restrictive or capable of being more restrictive if they want to be.
Then that's
should be
the
able to
law,
restrict it.
that doesn't need to be said. That's
Yeah.
just according to the property, definitely.
Well, we ought to know, we ought to ask the question, and the if they say, well, we don't want to close that opportunity, then we say short-term rentals are allowed.
Yeah,
But let's be specific about it.
Well, right now we have a cap for six. Oh, you mean like an actual process?
That was section G.
Mhm.
Anything further on that? Anything on H?
my extension from G is in H to just say in the zoning districts per the table rather than the specific SR, UR, and PUD reference that she has on the waiting list for short-term rentals in the, I just said various zoning districts per table, you know, where they exist.
I found this paragraph quite confusing. It states that the maximum number of short-term rental units has been met and no new application is accepted. Then state what happens if a waiting list exists, which leaves unclear how a waiting list could exist if no new applications are accepted. Then the application is served on a first come, first served basis, which is somewhat idiomatic and doesn't clearly describe how things work and is not, you know, I'm not sure that's the same as a waiting list. Can we use some approach, something like if the maximum number of licensed short-term rental units has been met, the city manager or designees of the city manager shall establish a process for determining the order in which subsequent licenses shall be issued?
I don't recommend that only because people, that's what people will complain about the most when they buy houses, and I see it in other communities. So I do understand this needs, maybe this needs to be clarified. I think it's more like the applications won't be, I could make that the applications won't be accepted, but a waiting list is gonna be kept. Or you just don't do a waiting list and it's just whenever they're free, someone applies. So in fair play, they didn't want to hold a waiting list.
A key thing here is I hate to write down the final way this is gonna be managed in the ordinance, because this can be a nightmare for our staff to kind of work on. If you have a waiting list, how long does the guy ahead of you on the waiting list get to come in and submit his application before you can put yours in? What if there's 10 guys on the waiting list? And I mean, how long do you give each one? They need to have the ability to have some process to manage, some ability to manage this process based upon reality and experience, I think.
Yeah.
So I would either have a waiting list or don't have a waiting list. So in fair play, this section, they just didn't have a waiting list. And it was like, no, if when they're ready, you go on the website every day or you call every day. That takes away the concern that you have, Lee, about the staff, so.
I would agree with Lee, because if we have a waiting list, now that's going to put that on staff to manage.
So I'm just gonna remove the waiting list provision.
Yeah.
And the first come, first
Yep,
served.
and then it's just on that person. If you get in there, you get in there. If you don't, you don't.
That's what they decided.
Yeah,
But
maybe-
make it clear that the staff can manage this process and adopt, reasonable rules to how they're going to do it.
Well, there's no need for that if there's no waiting list,
Right.
Well,
for the waiting list part, but.
I don't know how you can say it's on a first come, first served basis without having who's first in line and who's 13th in line. That's what the
Well,
purpose of the waiting list would be.
right, so that's what I'm
Eliminating both those clauses.
yeah,
Right.
But keeping the inventory on the city's
Oh, of course,
website,
yeah.
and it seems like that could be automated. I'm not
Mhm.
particularly computer savvy, but
Mhm.
automate that, and as a license became available, it would just be on the website, and it would be up to an applicant to watch the website.
Right.
I mean, an applicant's going to apply, it's going to get reviewed, and it's going to get accepted or rejected. And I think we should communicate the criteria for rejection, that there's already a maximum number of licenses in your zone district, or you're within however many feet of another one, or whatever, we reject it based on, we just reject it. And
Yeah,
then
so I think the
they
first
can apply
sentence is
again.
good. The
but-
first sentence is good. If the maximum number is met, no new applications are accepted. And then take away the waiting list, take away the rest. of it.
And they can manage
Okay.
themselves.
Let me give it a shot because I think it's still important. I wrote that next paragraph to read. And I'm going to introduce a new language and take some out, so just bear with me. The City of Woodland Park short-term rental unit application waiting list for short-term rental units in the SR, UR, PUD zoning districts shall be annually prepared and maintained by the city clerk. New licenses, once available, will be processed and issued based on the ability of the applicant to comply with all applicable conditions and requirements of this chapter 5.22 and within Title 18 as indicated within the application waiting list. And then I struck on the first come, first served basis. I thought it was just that issue.
I mean, that might be easier than figuring out how to not accept applications for licenses on Tuesday. And then Thursday, we have to accept them again. Then next Tuesday, we have to not accept them, and then 3 weeks later, somebody quits and we have to accept them again. I mean, how do you communicate that? That's more challenging, I think, for staff, but maybe staff recommendation might be warranted here as well. But I liked your language. I thought it was.
The only thing, and I do like your language too, but now that we have agreed to a table, maybe we just say in the applicable zoning
Zoning
districts,
district.
so we don't limit it.
Yeah, exactly.
I'd be agreeable to that also.
You're gonna send me that? I wasn't writing that down your part.
I'll give that
Okay.
to you.
Yeah, but just don't identify the zones, just say applicable zoning districts.
Tables.
Yeah, the reference to SRUR and PDUD should just be,
Yeah, definitely.
Yep.
It seems.
Okay.
got it.
Yeah.
Move to item I. Any comments?
I do have a comment. I thought this was kind of onerous and a little bit mean sounding to say all this to people. I had just thought the way I would word it, if I was going to put this in there, that makes it a lot less onerous on, mandating it and enforcing it and all this, was to say, for the sentence where it starts, the local contact person must, I changed the wording a little bit to say, the local contact person must be available for the purpose of responding to property code violations and or complaints regarding the condition, operation, or conduct of occupants of the short-term rental unit, and taking remedial action to resolve such violations and or complaints in a timely manner.
It's just hard to enforce.
Exactly.
So that's why I have the
But-
specific.
If we put this on this business, what about other businesses in town? I mean, this is like really onerous.
This goes to the policy reason is behind it is maintaining the residential character.
Yeah, but it's not, I think this is a lot more than short-term rental business would normally require. I think you need to respond, and a timely fashion is, if it's a big deal, you need to respond quickly. But I don't think you can hold them to 60 minutes response or being available 24 hours, 7 days a week.
Everybody's complaining.
Yeah.
A timely response is what,
It's not,
60
no
minutes?
one's like, it's 63 minutes. It's more like a timely manner. You can't enforce that. You might as well not have the section. So whether you could change it to 2 hours, but yeah, it's more like, yeah, what if there's that party? This is really just to be clear enough for when there really is that egregious problem.
Okay, so I do service level agreements all the time on projects with warranty services and other repairs, refrigeration systems, all kinds of things. And when you set a time limit, it costs some money because you got to have a person standing by for certain things. And this says a person needs to be on call with a pager, 24/7 responding, which takes more than one person. Now you have a 3-shift operation, 8 hours a day, 3 different people to service a short-term rental. I can tell you the short-term rental business does not require that to be successful and neighborly. The good neighbor policy that we're talking about putting in place will cover that. If you just have somebody who's a local contact who can be contacted, and I don't care if it says 24/7, that's fine. They can be contacted 24/7 and they can respond in a timely manner to address concerns. That's appropriate, I think, for the business. But this is a 3 shifts person working, having to be paid by a property management company, the way you've worded it. And I think that's onerous. I really do. And that's just the way I read it from service level agreements that I have to have for all kinds of things that support industrial projects.
This is more
So-
for, I think, just residential, to maintain the residential character. So more like the residential neighborhoods, but,
But the good neighbor policy, I think, is where we really need to hone in to make sure neighbors and others have, that the people are going to abide by that.
It's a policy, but that's not even enforcement, the way I interpret it. It says this, you should do this, you should do this. You should do a lot of things.
Well, I wrote
Those are
that
things
if they
people should
violate it,
know.
I know, she had it in there with some teeth.
yeah. This, I think it's important if you're gonna maintain the residential, and I'll see if there's a consensus for
But
that.
I don't think we should require that they have 3-shift operation and a 1-hour response. That's
Well, it could
like,
be response within business hours or response between like 7 AM and 7 PM, that's fine, but I think you just need to have specifics for that person who really is like. Think of the person, the people who have come and complained about the situation where it's like the party and this and that. So I mean,
Yeah.
I don't think it can be tweaked, but
I think it needs to be where there's a local contact person who can be contacted to resolve issues appropriately for the neighbor or for the complainer, so that it's resolved
In a
And-
timely manner.
in a timely manner. And most, I think, responsible property owners would make phone calls, make things happen if it's a big deal, so that this isn't, going to affect their business. But if it needs to be more than that, maybe we could do something more than that. I think we're done with public comment. I'm sorry. It's up to Ken.
yeah, it's anyway.
Yeah.
Or within 24 hours.
But anyway, I just thought this was a little more specific than,
I got another approach to suggest. Delete the sentence entirely and allow the good neighbor guidelines to decide to pick it up.
What do you think, Richard?
Good
I
neighbor
do think having
guidelines
a
are supposed to have a
reference
bunch of
local
stuff, and
contact
including,
person is valuable.
Mhm.
That's
Do
appropriate.
we need to define local?
To respond within an hour.
Well, what's a response? Is it in?
And it says, and taking remedial action.
I
This is very
called, showed up, or-
specifically, it's worded for a very specific
Yeah.
reason. A local person must, therefore, the purpose of responding within 60 minutes and taking remedial action to resolve,
What's responding?
They could call, yeah.
remedial action to resolve such violations and complaints.
They call the person who's staying there and say, hey, you left your lights on and it's shining in the window of your neighbor. It's annoying them. Turn them off. That may be
It's
the
a remedial
response.
action to
I don't
resolve the
know.
violation or
If
complaint.
they're
That's
passed
pretty.
out on the couch and can't go turn the light off, they have to come up here and turn it.
And they need to
Block the
go kick them
lights.
out.
Well, but then, we have to be careful. Who's
Yeah, I
gonna-
do too. I think it's, anyway, it just struck me as a little bit,
Right, but then who's gonna know who that person is responsible?
Because they're listed on the
They're
application.
listed, yes.
Because there's gonna be-
Yeah, this is like,
Right,
from
but
like
I'm
five
saying,
different- yeah.
right, but I'm saying if like, because I can echo some of the response. I have one who's literally right behind me.
Yeah.
And they had 100 cadets in this house.
well, I think we prohibit parties. I think now we
Right.
prohibit parties.
You know, and so it was like, we were trying to figure out who
Okay.
to contact. I mean, they were
So
parking in
are we
areas
looking at changing this section I or
Excuse me.
what's there?
Karen?
This, yeah, I need to chime in on this. I appreciate what you guys are trying to do and find that balance between a regulation that seems onerous as well as trying to take care of our neighborhoods and such. And the bottom line is those good neighbor guidelines are helpful and useful, but it's not in the regulations. So that is what's potentially challenging when you are dealing with that hardcore enforcement issue. So odds are if somebody's running a solid business that's not having issues, they're never getting calls in off hours. And it's more of a case of being on call and very rarely needing to respond to anything.
Right.
So from a staff perspective, that potentially needs to do enforcement or make contact related to complaints, some kind of parameters are hugely, hugely helpful. So I would recommend leaving the onerous language in place.
Because you only call for it when in those egregious circumstances. And otherwise, if it says timely, it's not enforceable. So, I mean, you always could say different times, but what if you want to call the PD because there is a party and it's violating, this is.
So I would support leaving it as is and moving on next, but
And it does respond to something that did come up in the town hall meetings and in surveys, is that people wanted someone local who could respond. This makes it very specific, but it does respond to that concern.
And I
I'm
want to
fine.
add that
I just wanted to make the comment that how it read to me was like a service level agreement with 24/7 and, and that's a big cost, a big chunk. And most, hopefully, most short-term rentals won't require that level of intervention. But
Right.
putting it in there gives it, people have to think about how are we gonna
Mhm.
take care of this if something comes up. And I don't
Is
have it, and I don't think any
That's purposeful.
conscientious property owner is gonna have a big issue with it, other
Right.
than they're gonna think, what does that mean I have to do? And boy, I feel like I'm getting slapped and I'm a good property owner and I don't have the complaints and I don't have a problem.
If they never
But-
complain, they'll never get called.
But it helps us with the ones who we need to put
That's the
some
purpose.
heat under.
Yeah.
So I'm okay with
It's
it.
very
I just-
rarely utilized.
Does Airbnb or any of the other platforms require that of someone?
They
who
actually have a lot of
registers?
requirements on, people who stay and owners and stuff, but that doesn't mean violations won't happen.
And within the hour,
And certainly the contact person is very common in all these regulations.
Is this the first time we mentioned good neighbor guidelines? Not that that's relevant. I just don't know if, all of a sudden we throw good neighbor guidelines in there. Is there something that, should that be included in the definitions?
I think I define it every time I talk about it, but I'll look into that.
That's a good point.
Um,
Well, I know we mentioned good neighbor guidelines with respect to the city manager. Somebody was going to publish them from time to time, update them from time to time. There's a paragraph about that.
Yes.
I believe it's.
Section I,
Yeah,
Yes.
so it's written about. somewhere.
so it's almost 9 o'clock. We're good to continue for a while.
Yeah, we're making
through it.
progress.
Okay,
Keep running through
so
it. That'd help. Yeah, I think we're almost done.
let's hope so.
I think. Karen
Anything
said-
else on this page?
I think Karen said we'll stay here until we die.
No, keep going. Keep going.
So the next planning commission's sworn in.
Anything else on this page?
Hey. The prohibiting, I didn't know if we wanted to go ahead and say we're prohibiting multifamily housing with these townhomes that are already licensed or not, or if we want to go ahead.
I'll just hold it. I'll look into the definition. I understand where you all want with that.
Let's find the definition.
I'll
of
look into
family,
it.
'cause
Yeah, I understand what you want with
I
that.
include.
Everything else I
duplexes
was okay
in my
with.
mind.
Yeah,
Like
What'd you say?
multifamily,
And under level-
duplexes.
And again, this is a good example.
I'll make sure it's defined. in the-
Which license are we talking about? Business license or the license?
Yeah, you're gonna send me, I'm gonna. look
Now,
at it.
and number L, maximum of one rental unit per 500-foot radius. I think our UR zone might be problematic doing that. There are clusters of short-term rentals in the urban residential zone. And
So I think my intent, what I'd like to see, I'm not quite sure how to get there, is to eventually have them spaced out, so they're not right next door to each other. Through property sales, lapse of licenses, revoke of the license, but how do we get, I don't want to be owners to people who have side-by-side units, so how do we?
well,
gradually-
these are in a weird position that I know of because they're all short-term living units. None of them are family residential homes. So you're,
So again, it's how, we got existing condition, maybe that's not desirable, I don't, unless we're creating specific zone for it, which I don't think we're going to. So if we have a separation, which I think supports the communities more, not having a group on 3-on-1 block or what have you. So I support having a separation between the units. I'm not sure what 500 is the number, if that's the right number, or not, I'm not sure. But how do we migrate when we have 3-on-1 street and to have them spaced out more? And
well,
so-
my question is even more specific. We have 3 units that are only used for short-term rentals. They aren't appropriate for family housing. Nobody would long-term rent them or live in them. They're only short-term rentals and they're within 500 feet of each other. And they're in the urban district.
So do you want only certain districts?
These are not in
500
suburban
radius?
residential. These are in urban
No, I was just saying
residential.
that-
I know the houses I think you're referring to. the ones
Yeah, the little
we
cabins
talked
that are over there.
about.
And urban residential is single family only. It's not multifamily.
Well, no.
I understand that,
Okay.
but these were built 90 years ago as short-term stay places. And most of them were summer only.
I've never heard of that.
The cabins on,
Yeah, that,
I know, but
South.
I've never heard of a state place. What is it?
a state.
A
belong-
state.
Yeah. They're Preacher's Row.
we're in the walking tour for Woodland Park on the little pamphlet. They're little cabins that these preachers built for summer stay, where they come out for the summer and they have no heat. Well, some of them have been upgraded to have heat so they can be rented out more often, but they've just migrated to be short-term rentals. And, there's no closets, there's no, it's kind of just like it's a little cabin. But they're more than 500 or less than 500 feet apart. So my only thing is where you have these clusters of these houses that were built to be short-term rentals 90 years ago. They were never built to be long-term stay places. This would restrict them from being able to be used for these short-term stay purposes. And that's changing the property value for the property owner. And they're not actually next to single-family dwellings maybe across the street, but I think most of the area in there is summer-only residences. I think most of the people who come just come for the summer.
Well, that's one good example, but I feel like our percentage cap serves as our limiting factor. This is just one more limit that may or may not be necessary and may not be applicable to the unique topography and the types of neighborhoods we have. I mean, in my neighborhood, it'd be easy to say only 500 feet apart, but in this particular case, and a couple of other instances where there are the old minister retreats, they're closer than 500 feet, and families will come and stay in them for a couple of weeks, but they also rent them out on short-term basis.
Yeah, so that is my only thing is again, the percent cap does a lot for limiting how many are in a neighborhood. So I didn't see this as being particularly valuable to have the 500-foot setback. Also, it creates, who's going to go out with a measuring tape and check. I think you'd rather say you can't have them in large groups or something if you wanted to keep it from being clustered.
I think this is an important provision for the protection of individual neighborhoods aside from sort of the overall cap kind of situation, getting clusters of these. I think the 500 feet is likely too large for urban residential, but for suburban residential, I think
That's
it
what I
makes
was thinking too.
I think it makes perfect sense, and we can look at exploring it further and try to. I think I agree with Chairman Hartsfield's intent of where we might like to get with this. It'll be hard to work this right now with the limited knowledge I have about the urban residential setup. Perhaps just making it suburban residential is sensible for the present.
Good compromise. That's why I suggested a field trip. So you guys could
Single
go.
family and PUD, you want to make
I
sure.
was thinking if we focused on suburban residential limit of the distance, that
SR,
would
yeah.
make better for
And
me.
PUD.
The 500 feet is fine for suburban residential.
We talked about that field trip at our last regular commission meeting. And I think that'd be a good idea as well, but let's advertise that we're gonna do that.
Yeah, more
That's
than
part
3 of you
our
can't
agenda.
meet without being noticed.
Yes.
Oh, sure.
Yeah.
I wrote a solution what I thought for this particular provision, and that is to add another sentence. And it says the 500-foot separation measurement shall be made in a straight line without regard to intervening structures or objects, which could include
Well,
topography,
radius is.
from the
So,
nearest
well,
property line to the proposed short-term rental unit to the nearest property line of the other short-term.
Larry is exactly right that it needs to be clarified. It doesn't say what the radius is from, and is a radius from a spot in a building, or is a radius from all of the boundaries of the property. I think usually you measure these things for zoning from one property line to another, and a definition, as Larry suggested, makes sense. I had a further thought substantively on this as well. Wondering, does the same considerations apply for owner occupied, the 500-foot separation for owner occupied rental units?
Oh, you mean
We-
long-term?
Yeah, well, I mean, short-term residential.
Owner occupied from the short-term rental ordinance, so.
Well, that's
how
just
would
the
it
renting of the
apply?
room. So this is, may I clarify, Commissioner Brown? In the beginning, you said, should we treat primary, let's call them primary residents. Should we treat primary residents different and make the caps or the 500-foot buffer not apply to them? So that's, I think, the policy question. If that's.
Yeah, exactly. That's my, I think 500 feet sounds sensible, but I'm trying to just wonder, does that apply to the commercial type units or does it also apply to the owner occupied units? If there's 3 people on the street that go to Florida for the winter, are they not able to rent out their property? I would like to think owner occupants tend not to be constrained by us in their ability to rent out their property when they're not home. Listen, owner occupied.
All right, so, yeah.
Well, the way it's currently set up, it would restrict any licensed short-term rental from being within 500 foot of another licensed short-term rental. the way it's
Exactly.
worded.
Yes.
And
Right, but he's talking about
Suburban.
the, there
and
might
if
be
we
the
do it in
distinction between
suburban
renting your
residential
room.
only, then that kind of fits.
No, No, if you're
Yeah.
just renting a room and you're present, I think we've carved it out
Yes, that's what
carved
I'm
it out
talking about.
entirely.
Yes. So it's a policy question of, do we want to treat primary residents different as it relates to the 500-foot buffer and or the caps?
No.
Right.
Oh.
I think this provision is the key to protecting existing neighborhoods from being over impacted by short-term rentals. Distance requirements will prohibit them from being cluttered and next to each other, spreads them out a little bit, and it provides for the protection of that neighborhood.
In the one zone only. Suburban
And
residential.
I would say we should do PUD too, right? Some
And
of those PUDs,
PUD.
yeah.
And BUD.
Take out urban.
I think so.
Yes.
Okay.
I already did that, so.
And that goes back to what I know about some of the clusters in urban residential and in the commercial district.
Hey, Carol, that's why at the very beginning, I'll say, this is the 3rd time.
Mhm.
I wanted to make sure that we understood that we were not grandfathering in
Correct.
Understood.
anything that's been approved by.
Previous licenses, yeah.
Oh, I agree.
And this you used is so unique that we're introducing commercial aspects into residential neighborhoods. And through our discussions with the city council and through our opinions as well, we thought it was okay to do it as long as we had adequate conditions and standards and revisions to protect the neighborhoods.
And then conversely, our ability to enforce it.
Exactly.
I mean, somebody's gonna have to have a plat when they come in for their license in the suburban residential to prove that they are not
Yep.
less than 500 feet apart.
And I think
It's
when
reasonably interpreted through the assessor's information.
Sure, sure.
And I think maybe when we're all said and done, we look at what we think we should do, we might look at this and scratch our head and say, this is not a simple process. And it doesn't involve more staff, enforcement, more energies, monies going into enforcement for this provision. And it's getting complicated.
Yeah, I don't want to make it any more complicated. That was the whole point. But when I think about suburban residential, I think about my own neighborhood. Most of the lots are an acre or more, acre to acre and a half. This will never be an issue. So why even include it?
Well,
Not all houses are that well separated in SR.
I'd like to review. that
And why
argument.
500 feet?
Well, that's another issue is
Yeah.
what that distance should be.
Yeah.
And
If you
from
look
where?
at those particular cabins that, in addition to the one that we looked, that Ken showed us, maybe
The
it's
other clusters that
200.
I've seen on the map that shows, where all these are kind of at, a lot of them are in the commercial zone anyway. Where somebody's got some kind of residential property that's been updated to short-term rental stuff. So, but there are these few clusters in the urban zone that I've noticed that if you look in that area, there seems to be more density. for short-term rentals. And I think it might actually be an advantage to have them together rather than spread out throughout neighborhoods. And a suburban residential, I think it makes more sense to limit however you want to limit them, preferably by homeowners association deciding we don't want them and they don't have them. But anyway,
You know, as a way to address that, we can also introduce the concept of exceptions to the rule. And say, here's our rules,
unless approved by.
or
You don't do that.
Don't do
These
that.
these units on Preacher Road.
We're thinking the
are
staff.
Yeah. I
Don't do
know.
it.
Well,
Like I
We
said,
would
it's,
still
it's,
do
Excuse
that.
me,
it's possible that could be rezoned as a commercial too or something maybe.
Maybe we could just depend
Karen?
on.
Ms. Gummer?
thank you. Yeah, this is absolutely goes to the heart of the policy conversation you guys are having. And I think the 500 feet comes about because that's a pretty substantial distance where you're likely to have at least one, if not two lots in between, you know, each where a unit is located, you know, and sometimes potentially more. So I'm a little concerned that, well, it's good that you guys are talking very consciously about how do we preserve our neighborhoods, but a little concerned that this urban residential zone is almost starting to feel a little bit like a sacrifice zone. Well, we already have that there. Well, that's already there anyhow. We've already got clusters. And that is an area of the city that does have smaller lot sizes. So perhaps a smaller radius would be more conducive to meeting that desire to preserve the residential neighborhood, and I guess to kind of balance that a little bit better. And you know, we at a staff level could take a look at that for you in terms of like what are our lot sizes within that UR zone, and that might, or in our lot frontages, that might help a little bit with identifying what should that number be.
Yeah, I
And
don't have
then-
a
to
listing
what
of the size.
Commissioner Brown said, he mentioned that, yes, it is typically measured from the property line out, you know, that 500-foot distance. And that's actually pretty easy to do in this day and age with the magic of GIS. Thank you.
Yeah, the urban residential, I just see it on the zoning map as a smaller area. And there's 7.26% of the current build out as short-term rentals license properties there, only 40. And the suburban residential 77 or 4.76%. And I know it's a much bigger area on the zoning map. So you're right, those different radius is probably appropriate for urban residential.
I think we could look at the different radiuses for that. and I
So we'll
do
come
agree.
back with that
It should
maybe.
be from
and
the
maybe-
property lines.
Yep.
All right, can I
agree with
suggest then that we write it as applies to suburban residential and PUD, and have a second sentence with a blank number in it, and take Karen's offer up that she'll look at it, and when we do it next time, we can hear comments from staff as to what that difference might be in the UR zone.
Good idea.
Do
Very good.
we need to spell out contiguous versus across the street?
No,
I
the
think it's
distance
a-
covers it.
Okay.
I agree.
Anything on item?
Oh,
M?
by the way, we skipped K when we got to L. I had just kind of a question out of the blue to ask. The structures it's prohibited from operating short-term rental. What about dormitories? Should dormitories be prohibited from short-term rentals like apartment buildings and bed and breakfasts and campgrounds and RV parks?
They're in a PUD.
Yeah,
Get it? Sure.
it seemed like they're the kind of building that would be covered by that list too, but aren't covered now.
I added it.
Yes, let's have that. Anything else on this page then? Yay, page 4. Application issuance and renewals. Any comments on item A?
That's where I brought in the suggestion about, I know this will be complicated, but we're getting at the end of the year. And if we're going to be requiring people to get applications and pay fees for 2022, And then a month later, we're asking them now to pay for 2023. I think we need to, because this ordinance might not go into effect until November, December, kind of look at a hybrid that kind of consolidates both. That's a challenge for you.
Yeah, I'd rather not put in the code and then just give an exception for the one-off, like this year. and
I
not
know
put in the
we've
code.
got wording in the charter that talks about after the passage of this ordinance and then establish your regime period.
Excuse me, Nina,
Yeah,
could we perhaps put a section at the end where it's not part of the code, but it provides that transitional language? You know,
perfect.
whether it's like I don't know if you want to renumber or not, but under that section 7, 8, 9, you know, in that
Yes, I
area.
like that idea, exactly. So it addresses it, but it's not in the code forever, because then, you know, in 2037, we see the code. I will address that. And thank you, Karen.
Sure.
I added a clarifying statement that a license will apply to a single address property, and each property owner desiring a license will require a separate license for each property or something to that effect. And I don't know, we made that clear
Redefine
now.
unit, Yeah,
And that if you just make it
yeah. I'd
clear
rather-
somewhere,
I'd
that
rather
doesn't need to
do
be
that
here.
unit. Yep, yep.
Okay. I just caught it there
I appreciate it.
and I want to make sure we include that.
Any other comments? Going on the page?
Oh, on page 4,
Yes.
paragraph 4 of section C4,
Yes.
where it says there have been no violations. I was thinking that maybe that should say
That
there,
makes 15. Oh, wait, no, that makes 18. Sorry. I'll let you
there are
talk.
no outstanding violations, maybe is what I was thinking. I don't know if we can say one and done on every property. You've had a violation, so you're out.
No
Can't say
outstanding
there's
means.
no outstanding.
Why
no
why don't we
outstanding
put the more
doesn't
than
get it.
one?
I'll say,
You were talking
if you say
about
no
three.
outstanding, once it's done, it's done. So as long as they're not on the moment to bring an application, have an outstanding, that would never, it would seem like this is sort of thing, we don't want to say that it is one and done. But ask Nina, is there room for judgment by the city to decide between, if somebody has had one or more violations or two or more, or whatever we decide on, to make some judgment? Was this just a crabby neighbor who was,
Well,
making
complaint
calls?
is not a violation. So to get to your point, what everyone's saying is I maybe use the same language in 5 as in 4, more than one violation. Because then there's 2 violations proven. It's very, very, very hard to even prove one. So I think, because you gotta go through due process. So I think if instead of no, there's been no more than one, to make it mimic that 5, no more than one. That's what I would recommend.
And certainly a violation could be hard. I mean, it could be really kind of impacting the neighborhood, where another violation, who cares?
Right.
It's still a violation. So there's got to be some flexibility built into that.
I put more than one. I think this language is probably on so many codes and has never, ever been an issue. It's only the issue that 1 out of 1,000 that's a problem. Because it's an established violation that's been proven, especially if it's a code violation, it's gotta be probably proven.
I don't think anybody disagrees that a short-term rental business that's operating inappropriately, causing a lot of problems, doesn't need a new license or a renewal.
Right.
The issue is if you're a good short-term rental company and you're doing a good job and you're basically under the radar, not bothering any neighbors,
Right.
and you have some tenant that comes and screws something up one time, do you not get to keep your short-term rental license?
Yeah.
It's like probably a 1% over 1% chance that that's been written in municipal court, proven by a judge, pled guilty to. It's like it only happens in the very egregious cases. And that's why in taking consideration what you're saying, I'm going to say.
But we do need a way to not
more than
renew a
one
license of a short-term rental business. It's not meeting some standard or.
That's why I had this all.
Yeah, okay.
It's never been,
If this is the teeth you need, I guess that's fine. I
Yeah,
just
for
was
those
thinking
guys.
it seemed a little one and out. So if you put the other language in, whatever you said
no more
about
than one
that.
violation.
Yeah.
And as part of the application requirement does also refer to the signed affidavit that's understood.
Page 5.
Do you have page numbers of yours?
I wrote them
I
in.
should have, actually, I'll do it now. In this next version, I'm gonna put the page numbers. Oh, I have page number 1, 2. Okay,
And
sorry.
we get some page numbers, not consistent.
Sorry about that.
All applicable requirements, top of the page.
Did we make it clear that you can't have a person have a license for a short-term rental business and transfer it to another property?
Yes,
that they own?
non-transferable.
Okay,
Yeah.
I had that question on E.
Yeah.
So it says no,
Oh.
yeah, no license shall be transferable.
And I did think that the 10 days on the D was maybe a little tight. I was wondering if 30 days would be more appropriate for doing any kind of city business. Or.
Any
fix things.
information, again, that's only when these people come, it's fine, we'll change the 30.
I don't know. Do you
Yeah.
guys, on item D, 10 days is a lot.
I changed it.
30 days is what I thought.
To update the city within 30 days of the change, yeah.
Yeah. And the same thing on the 522-040 in the first one, or upon 30 days written notice by United States Postal Service. to the
Oh, no,
license.
that I do not recommend. Because
Okay.
that's in the egregious case that you are actually bringing someone to hearing, you do
So
not
we
want to
needed
wait
10
30
days.
days, yeah.
All right, I'm
that's-
fine with that.
No, I'm just to explain it. It's different, yeah, so sorry. And again, you hardly ever get to the situation, it's that 1 out of 1,000 that you all really want to get to the hearing.
Oh, there's-
522.50 penalties. Anything?
Our penalties are covered in the code, aren't they?
Yeah, so this is just saying, I recommend this language just to allow you to add the fine, otherwise it goes back to that chapter 1.
We used to be able to put people in jail, but I think we changed.
Well, I
Depends
drafted
if
a
they
code and
got
it was
the house or
rejected, right?
We're gonna put them in a short-term rental.
I tried to decriminalize the code, but it was rejected.
You might like the
But that was a
short-term
previous
rental.
city council, so I might
Sign
bring it
30
back.
days in a short-term rental of our choice.
The sheriff's got room.
All right, must be getting late.
Yes. Was that different page numbers needed there?
I don't have
Sorry.
pages.
Yeah, there's numbers.
Sorry.
Short-term rental business. 18.
So now this is just to clarify, Chairman, sorry if I don't interrupt.
Yes,
Now we're in Title 18. So this is just, some of it's duplicative, it's purposeful for the actual, your land use code regulations.
Yeah, I didn't have any comment on the business, but on the rental unit, I just thought, we need that same kind of thing about
Language.
the room in the corner of my own home where I live is
Mimic
not
the other,
part of
yeah,
that,
mimics-
however you do that.
Yeah, mimic Title 5 definition.
Then the table of uses, I had whether or not we would include some kind of
Mm.
permitted conditional use in multifamily, suburban, multifamily, urban,
Yeah. we talked-
if we decide to set a limit so that we don't restrict them entirely. But other than that,
And I guess that goes, well, anything else on section 4, section 5? Section 5, the table. Larry, you had some concerns about what a permitted conditional use is.
Yeah.
And I'm a little
no-
confused
no-
by that too.
Nowhere in our code do we define that. And I think if we're going to refer to short-term rentals as being PC, we need to define it now.
Yeah, so I'm gonna make sure the code defines what that means. I do
Well,
want it to say PC
Yeah, I
versus
thought it
permitted.
did because.
Well, I'll look. I didn't look today.
Well, and
additions,
speaking,
Yes,
I
Karen.
think the conditions, I'm sorry.
speaking as the new staff person, I can assure you that nowhere does it explain what permitted conditionally means, which has driven me a little crazy. But, and there are other uses in our table that are permitted conditionally already. But what that really means is, yes, this is permitted, but you need to look at this other section of our regulations that contain what are typically referred to as supplemental use standards. And so
I was
that's
wondering
like
if the
the rest
conditions
of what
were
we've
the
been talking
percent
about.
limits.
Yeah, I agree,
here.
Karen. That's what our other codes written. So I think it's like more of a TBD, like to change the code to make more clear in the future. It wouldn't be proper to be in this ordinance, but I think you still should keep the PC and quickly change that code section because I agree it's a problem.
Yeah, and I think, permitted use, it's easy to say you're going to meet all performance standards, or you're going to meet all noise and that's understood.
Building code.
But this is like-
But Karen's 100%
Yeah,
right.
agreed.
Permitted conditionally means there is another section of the code you need to go.
Which is
read.
Yeah, I agree. Which is.
Yeah, I agree.
Well, yeah, and under each zone, there is a subchapter for permitted use and conditional use. So do we, that'll just be part of this ordinance, wouldn't it? Permitted use and conditional use.
With
Well,
this particular ordinance, yes, we can add a definition for permitted conditionally. Because we have, there's also conditional use permits, just to make things clear as mud.
Yes, we should add, define that term.
What?
Mud, yes.
I know where Dr. Mudd's buried and where that phrase came from.
Really?
And he was the attending physician for John Wilkes Booth.
That's right. Oh, and that's right. It's clear as mud.
Anything else on section 5? Section 6?
A small one. 1878-050 B2, just consistent with what we talked about a few minutes ago, dormitories are also not, short-term rentals are not permitted in ADUs, bed and breakfast, campgrounds, RV parks, et cetera, dormitories.
And it,
Okay.
Okay.
That puts us on the last page of my document.
yes.
Any comments on the remaining sections?
Let's talk about section 6.
Okay.
Which is section 1878-050, short-term. It says rental units. And I've got a couple under 1, A1, all short-term rental comply with unit. Never mind, we already talked about that. Under B, it just simply says standards. And what I would like to see as I add is short-term rental unit standards. The city planning department shall review and either recommend approval or denial to the city clerk of all new and renewable applications for short-term rental units based on the following zoning standards. And then we have a list of 6 standards that are included there. And I'd like to introduce 3 new standards, and I've called them new. And the first one would be short-term rental units shall be permitted conditionally only in the zone districts as specified in code section 1809, table of permitted uses, just to clarify that.
You're sharing this with me, or am I taking notes? Are you gonna share that with me also?
Mhm.
Okay, good.
Like I said, I'm going to give you a copy of.
Perfect. That's why I'm not typing
Okay.
or writing.
Next would be ensure that maximum number of short-term rental units within the SR, UR, UD zoning shall not exceed the established cap. Okay, what we need to do is just do that, make sure it doesn't exceed those requirements per the table that we just talked about. Last new section I would introduce would be that a maximum of 1 short-term rental unit is permitted. Again, it's talking about the planning department, it's a zoning requirement for the separation of the radius,
Whatever that is.
whatever that is.
Applies.
Agreeable to those.
Thank you. I have a comment on existing zoning standard 6, talk about parking. And it says designated parking for vehicles, short-term rental guests shall be addressed at the short-term rental application, the license stage, and shall meet the off-street parking standards for that particular unit identified in chapter 1839. Well, we don't have any parking standards for short-term rentals in that section. So I'm suggesting that we formulate some standards for parking in this section right here, for we don't have to change the table.
Well, is that not already specified by the type of dwelling?
Like if it was a townhouse, if it was a single family house, it follows that, but that, I guess I should be more clear.
Well, for a single family house, you record what, 2 off-street parking spaces? I believe.
Yes.
Is that what we're trying to
Yeah, we just,
implement? Is that adequate for?
well, we need to know if that's gonna be adequate for the short-term rental.
Yes. I guess that's part of the application process.
It could be.
We do, I do talk about a parking plan that's approved by staff in Title V. And then if I do need to be more clear as to this section, what I meant, and you could clarify if it's not what you want policy wise, but what I meant is like, if it's a house, it's two parking, whatever the
Whatever
table
it
says.
is.
I believe that the proper place for short-term rental standards for parking should be right here in this section of the code, and not in the parking.
But it'll be different for every type of building and every zone it's in.
Well, shouldn't there be some similarity for short-term rentals?
Downtown loft apartment.
Well, you guys are making good points, but I couldn't find them in 1839.
It doesn't say short-term rental, but it says like maybe townhome, single-family house. So whatever it actually is.
So the objective here is to be responsive to some of the comments that we have heard about STRs really filling up the street with all kinds of additional vehicles. So the use that typically gets built, it was a single family home, and there is a parking standard associated with the construction of a single family home. So this is kind of an ancillary use that shows up later where somebody says, hey, I want to rent this out. And so as part of the licensing process, we're asking folks to demonstrate how many parking spaces do you have available. And I think that's potentially going to go into exactly how much what is the occupancy limit for the short-term rental? Those things will kind of go hand in hand. That was part of the thinking. And I don't know that we've drilled into that at that level of detail within these regulations, but the bottom line is to make sure that there is off-street parking available for the short-term rental unit.
Don't you need a standard to be able to determine that? Or do we just trust that? I'm kidding.
I can understand where you wouldn't want to do that.
Larry, there are some descriptions of parking spaces per type of business and per type of building.
Anything
The
close?
trick with short-term rentals is typically somebody is not constructing just a short-term rental building. It's a single family home that then sometimes ends up with this use.
But then you also have the possibility that it's in mixed use zoning, the apartment building over the business.
Yeah.
And we require in Title V a parking plan. So it gives the staff the ability to say,
No or yes.
Yeah.
Well, I kind of interpret that. I mean, here's where the parking space is going to be located. On the property.
Right, and how many
It doesn't
spots.
talk about the number of parking spaces that you have. If you have a single family home, like I assume most of us do, we have a garage, we have
Right.
a driveway, and we meet the requirements for the number of spaces in those two places.
Right.
And now we're adding more people coming to the site, and just like Karen said, we don't want to impact off-site, on-street parking in the neighborhoods. So we need to have you need to provide a number.
But then how do you regulate that? I mean, I've,
You
Is
state
it one
It would be in
space
the-
for two occupants?
It would be in the parking plan.
yeah.
number of occupants is a good way to go about it. I don't know how else, but
It's done many different ways in different codes, so it's up to you guys what you want to do. But it is enforceable because that number and the requirement would be in the parking plan and staff would look at it. It could be each bedroom. I've seen it on each bedroom. I've seen each bedroom plus one. I've seen it just follow the unit, which is how I have it drafted now. I've seen it done many ways, which is up to you all. If parking is really a problem in the community, you know, it's really up to you.
And it can
It's
be.
adjustable in the future.
Yeah. But we need some. We just can't go back to the parking table because
Mhm.
we don't have anything there.
But we've also prohibited events, weddings, concerts,
Yeah.
which would hopefully
But aren't well-
prohibit.
Those functions aren't well defined, but
Yeah,
In terms of going back to the parking table, no, short-term rental is not listed there, but it is a single family home or whatever type dwelling unit it is. So that's what we're looking at. And especially with single family residences, the standard is 2 off-street parking spaces.
That's for a single family home. I agree.
Right.
But if we're going to introduce part of that single family home, a short-term rental, that's going to bring another vehicle to that site. Or more. I don't have an answer. I just have a question.
Yeah.
well, that goes back to, I thought we have discussed that someone will not be subject to this regulation if they're living in the home and they rent out
A room.
space.
One room.
Where did we add that at? I didn't see that in.
It's in there.
She's making it clear.
we've had the discussion.
We spoke about it tonight, so I haven't updated yet.
I was thinking my.
I know we've been here for.
No, but anyway. Yeah, most of the time, a short-term rental will have an occupancy because we're setting the number of
Yes.
spaces at the license time that it can occupy.
As long as we have the discretion, staff has the discretion. to
And
determine.
she's requested that they provide a parking plan at the license, so staff will see how many parking spaces and how many beds and how many people. And so at that point, the license, I think they could say, you know, that requires 4 parking spaces for 8 people.
Does it?
I don't know. They might be able to say that.
That might be the best we can do.
Might be the best we do, but
Well,
we are getting.
If that's
parking
the approach,
information.
if
And how
that's
many
the
beds?
approach if that's the approach we're gonna take, you don't want to say the parking standards for that particular unit identified in chapter 18.39.
No, you don't.
The 18.39 just says 2 for the building, and the fact that it's got 6 bedrooms and, you know, rents out to 18 people or whatever it comes out to be is definitely not addressed. So at the very least, take out the cross-reference to 18.39. I'm not sure you've quite gotten discretion there authorized, but at least you haven't canceled any possible discretion.
I think we need to craft some language for some discretion. Somehow, some way.
Well, then I would also suggest that we further define subparagraph 5 under section 6, events such as concerts, parties, and weddings are prohibited. Can we add a little more granularity to that by saying events that would exceed the number of
Occupants.
approved occupants?
Which is what, 2 per bedroom plus 2?
2 more, yeah.
That's a
You mean like the building code approval of occupants?
Well, I thought we did define that in here.
Oh, do we?
The building code doesn't define number of occupants.
Well, when you say approved amount of occupants, where is that? Is that somewhere else in the code? Title 18?
No, I thought we had that as part of our, maybe.
At
we
one
don't.
of the meetings, we talked about 2 per bedroom plus 2
Yeah, but
as a standard. I don't know where it wound up.
That may have been in one of the attachments that the staff had prepared.
Oh,
That-
and the affidavit, maybe? the
Yeah, somewhere.
Policy. Well, I
I
think
think a
we
large
do.
events now for now, and then we could look into exceeding.
Yeah, I think we do need to, somewhere in here, whether it's in the good neighbor policy or in the ordinance itself, the ordinance itself, that might be too perishable, but we need to say, you know, no, this is the occupancy limit.
Yeah, I had that before, and we weren't sure if the utility director, I had it before, I had like no more than the, whatever the EQR, whatever they would, a permit on that property in terms of utilities, but Karen said we're not sure, we haven't spoken to Kip yet about that. So
Well, that's true. I mean, you don't want to overflow the toilets.
But the total.
Yeah, and that is exactly where you had it, Nina, previously was tied to utilities, and that was problematic for us. So finding a different mechanism or trigger is probably what we need.
So I think we should limit the occupant load of the house to be rented out. And I think based on bedrooms is a reasonable approach. to do
I think
that.
I would imagine Airbnb and VRBO and some of those already do that, but it doesn't mean that we're gonna get it done just because they do it. And I don't know for sure, but it seems like it would be pretty impractical to say a place can hold 8 people when it's only got, 2 bedrooms with 2 beds or something. That would be kind of crazy. So I don't know that that's actually happening, but 8 people showing up at a 4-person accommodation, I'm sure happens, because I know people try and jam 6 people in a hotel room that's got 1 bed. It happens to hotels, but so it must happen in short-term rentals also. They say there's 4 of us coming. Yeah, you can rent our place, and they think 8 people show up.
I mean, once we get our new draft back, I mean, we can have that discussion, but we've not identified that as a requirement, occupancy limits. And then tie that to events being no events that would exceed the occupancy limit.
Right, so right now I just put large events, and then maybe we'll have to think about if you want to further define occupancy limits.
I know there are people who get short-term rentals and then have book clubs while they're there.
Going crazy up here.
Do you want to have the occupancy limit in the licensing section rather, is that perhaps better than putting into the zoning?
Sure.
Yes. Yeah, we're just doing a conversation.
So the
I think you
license-
wanted to call the city on the book club. But you never know.
I've been to one.
Yeah, but I'm sure that no one would call the city and complain unless it got really rowdy.
No, we bring wine.
Well, I mean, somebody's gonna stay in a short-term rental and somebody else is renting a hotel room in the same place and they're all visiting together. The 2 people are gonna come over
And
and visit and eat breakfast at the short-term rental or go to the restaurant together. People travel together and stay in separate places. So they're gonna get together for a few minutes.
And nobody, it's
talking
never
about-
gonna be an issue. No
I
one's
know,
gonna
it's
be
not gonna
like.
come up, but the issue is
Does give
we
us
can't have
benchmark for
an
enforcement if we
event.
need it.
Right.
We can't be having an event center out of a short-term rental
Right.
or
That's why I put large
a
events.
single family house in somebody's neighborhood.
Right, and so you want to bring the RV into the backyard.
Yeah.
There's like tents popped up in the yard. It's
Sounds
got
like experience there.
It was fun.
I like the idea that parties are prohibited too, because once you introduce a party, you say it specifically, they're prohibited.
Yeah.
You're just going to have a mechanism of enforcement. to say,
Yep.
You are violating your provisions, good neighbor, so on and so forth.
Well,
Section 7.
section 7. Any comments?
Well, I think the whole process of, once we reach our gap or cap limitations and how we grant license or permits or new ones from that point needs to be reworked. This section is kind of cumbersome, but I don't have an answer, Nina. It's just that I read this and I just, how are we going to do that?
It's just practically, the people who are, we give them lodging, whatever, we give them lodging license, ability to pay lodging tax, that if their applications will be considered first. Because you could have a cap and then 25 people apply that are not currently operating short-term rentals. So it's more giving, again, it's on the ordinance, it's on the code itself, but it's just trying to take a practical stance for the people who already have a business license. I mean, if it's, just I'll note to try to make it more clear, but I think it's a good idea if you're gonna have a cap.
So if we're working on keeping that cap or maybe even getting rid of the cap at some point, like we were in some of the other areas, would it be prudent to say if you sell this house, you don't get to transfer that license?
It already says,
somewhere
yeah,
else?
not,
That's
yeah,
already in there.
That's in
Yeah.
there.
there's it says non-transferable.
Right.
This section 7 is only for the first 2 months, and maybe we need to say that, but
Okay.
I make that more clear. The first 2 months when this ordinance becomes adopted, where people are applying. So that's why I put it outside the code. But I made sure, to your point, that these licenses are not transferable.
And again, I introduced the idea of the waiting list under this section. That somebody could get on a waiting list and maybe wouldn't have to continually monitor when units become available.
But then
But
the
the-
staff would have to contact them.
Exactly.
I
Are
would
you
put-
still interested in doing this?
I thought we were gonna do away with
Put
that.
the onus on the applicant
Mhm.
to monitor the website.
Okay.
Oh, that was, I think that was different than I thought, but section 7 is only, I'll make it clear, it's only for like, let's say the first 2 months after this ordinance is passed, for the people who currently have these business licenses for a short-term rental use, that they'll be considered first. That's what that means. But the waiting list, I think we kept it because we said just, well, I wrote, see Larry's language was edit. If waiting list is in the new table, it will be issued on the ability for the person to comply. It sounds like we want to have mention of a waiting list for the staff, but then I deleted the last sentence that we didn't like. Does that make sense?
Well, I don't want to obligate the staff to anything, but I guess we should say the vacancies will be posted on the city website. Waiting list to me is not applicable any longer because they're going to be looking themselves.
It just, you guys went back and forth with that, so I remember deleting it, keeping it. So the cap section, we have the website, but then you kind of went back and forth. Do you want to have a waiting list? Do you not? If you don't have a waiting list at all, it's just everybody they look every day at the website, which is fine, and they apply.
Yeah, and I think that's gonna be a little more difficult to know what, I mean, if the staff gets a license and they have a list of applicants pending, they issue the license on the next available applicant. If we have to post on Tuesday, a license became available, and then get a flood of applications or whatever, pick the first one, and then take it back down that there's not one on Wednesday. And then next Thursday, somebody cancels a license or however many happen at the end of the year. It's just going to be more problematic, I think. But again, we had that discussion after the waiting list thing, and that's why I kind of waffled, and some of us went back to waiting list is probably potentially easier for everybody.
It is, from the communities that I've seen. It's because it's just one list somewhere. It's
Right. And so that's where I think it came back, is when we talked about that.
Well, then you put it back on the staff to contact the next person on the list?
Yeah, I mean, they're going to contact the person who applies anyway, whether it's 100 people each time one goes up, or there's just one on the list.
Because the application's already fully submitted and they.
Yeah, in the meantime, the individuals turn it into a long-term rental. I don't know, I just,
Yeah, I don't know.
I don't know how.
What do you
They can withdraw their
Gary?
application, I guess.
I don't know how fluid the.
I think we need to think about this a little bit more.
Well, the whole process needs to be thought through too. And one that I'm wondering about is when we get to the end of the year and everybody goes to renew and the cap is been set and 10 of 40 are not going to get one this time, which 30 get
No,
it?
you automatically renew. It says here.
No, on the first part, but I'm just saying in the future, if the cap is changed for any reason, or if we cap the multifamily for next year at 1% and it's already at 2%, and we're gonna, or we say it's 0, and those 11 people not getting it, that's easy, but 5 getting it and 5 not, or 10 getting it and 10 not, after they've both had them for several years in the future, whenever this comes up.
Yeah, I would recommend the cap being slightly above what it currently is, just from a practical standpoint. And that's why I have section 7, and that's why.
Then as they get out of the business, then that's
Oh, I
when the
care-
next person gets one.
Yeah, then you could care less, because then it's like up to them to.
Or we could change the cap and lower it as the
Yeah, it's
right
just-
rental
it's-
licenses go down.
I would still like to think about it. I'm leaning towards Carol's idea of let the applicant contact the city and say, is there anything available in my district? And let that responsibility go on the people that want short-term rental and not on staff.
Well, because then, like my issue would be is if I contacted Carol and said, hey, there's an opening and Carol took 60, 90, however long it takes, you know.
Do
and then
do
you
we
guys
need to
just don't
determine the
mind.
method for that in the ordinance, or can that just be the staff
So for
determine
what?
that method of how they want to deal with issuing licenses that are available
Well, can we ask Karen what her?
by
thought
waiting
is?
list or by not?
I
Can the
mean,
staff just
Karen-
determine that?
Staff would be the one doing it. Do you have any thought on that, Karen?
Right.
Before we pigeonhole you into something that may or may not be more work.
Possible.
You know, flexibility is definitely desirable, especially since things can change over time in terms of where and how we spend our resources. I think potentially something that involves less phone calls to staff is helpful.
That would be a
Just-
waiting list.
Yeah, because I'd hate to be taking the same call from that person, you
Yep,
know,
they'll call every
every
day.
week.
They'll call every day. Yeah, that's why this, in Salida, they have a waiting list for years and it's worked really well. It's literally just a list.
Do we want to give them a certain amount of, like, cap them at a certain, you've got 30 days to get your application into us, or it goes to the next person?
It says, new licenses once available, we issued based on the ability of the applicant to comply with all the conditions and requirements. So staff could consider, it would be in staff's discretion. I don't think we need to get that hyper specific.
Okay. I'm just talking from the waiting list perspective, not from.
Oh, yeah, I'm reading the waiting list, yeah. So like
The
new licenses.
language I suggest, we talked about this before. They said if the maximum number of licensed short-term rental units has been met, the city manager or their designee shall establish a process for determining the order in which subsequent licenses shall be issued.
The only reason I don't recommend this is because I've seen it in practice. It's the only thing that people really do. They really do focus on that. They really want to know the definity, the objectiveness of this, the waiting list purpose. Either don't have one or have one, but to keep it open to the city manager for this purpose, I just wouldn't. These licenses are worth a lot of money, and that's what people, they want some definitiveness. I've seen it play out for this. I don't usually think that for most things, but for this, I see that. That's what I just see practically.
Is that language we could add down, that's language we could add down the road though, right? If we decided to change our mind and.
People are putting a lot of money into this, right? So they need to know where
Yeah.
they stand.
Yes.
Yeah.
Yeah,
Yeah.
and I've seen it.
Especially
either
the
don't
people
have a
who
waiting
are
list or
applying for
have it.
short-term rental license with their lot that are getting ready to build it.
Right.
We need to talk about that one at some point, probably.
Well, yeah, Ken just reminded me, we had talked about not allowing people to apply for a lot.
A license when they
lot.
have an empty.
Oh,
vacant lot.
definitely.
Yeah.
If that's not clear in here, I'll make it clear. We have that in Salida. That's,
Maybe just say something that's.
well, because the
established.
definition of a unit, you have to be a unit. You have to
Okay.
be a residential
And
unit.
an address. So.
Yeah. So no one with a lot, if they built their home for a short-term rental unit,
I think we
Sorry.
made some
Sorry, yeah.
reference to some people with lots applying for licenses when the moratorium was about to come in, maybe.
I'd heard that. I don't know.
I
if
think
that's
somebody
urban
mentioned
myth
that,
or
maybe
not.
somebody in staff said we got a few of those.
Yeah.
So
and they
we'll
were
have to-
told, what were they told? They weren't told anything,
I
right?
think they got the license before the moratorium went into effect.
Well, that's because we didn't have
It's a business
regulations, hence why you need this ordinance. You need
There
to
you
have
go.
regulations. So anyone who thinks so, sorry, I feel everything, anyone who says that you shouldn't have any regulations, you obviously need to, all these things you need to be, well, it's up to you how you want to define it, but it needs to be regulated, defined in whatever way, yeah.
And then it always comes back to interpretation.
That's why you want it as short as possible.
Any comments on severability?
That looks pretty typical.
Lee? No. Karen, I think we're through the list. Any comments that we need to go back and revisit?
I'd like to introduce a new subject, and that is public notification and having the public have an opportunity to review what we're going to have at the public hearing.
There's no public hearing required right now for short-term rental.
No,
No,
as far as the
I
ordinance
want the public
approval
to be able to
recommendations.
have the ordinance in their hand and review.
Oh, yeah, so Karen said that the next meeting will be the public hearing, and that's where we'll do it, and then there'll be the city council public hearing.
Next meeting's in 2 weeks.
September 22nd.
Is that going to give us enough time to draft all these changes? To,
Good point.
we still identified several issues we still wanted to flesh out a little bit, so we won't have a final ordinance
Are you suggesting another special meeting?
Special meeting, or I don't know what's our schedule for our next meeting in 2 weeks. If we could do another work session then, but I think it's very important that Jerry gets a copy of the ordinance that we're gonna have for the public hearing, for he can go through that. And he can address point by point the items that he agrees with or does not agree.
Who?
He-
This guy that's been sitting here very
The public.
patiently.
The public.
He's representing the
He's the
public, but the
public.
public.
I thought you were talking about.
Well, that's that goes without saying. It fell through the cracks. I'm not throwing rotten tomatoes at anybody because it happens.
I know, but for this work session tonight, it would have been very helpful to have the public have a chance to review what we're looking at, for they can comment directly.
Oh, I
on this
agree. I
page.
don't disagree at all. I'm just
Yeah.
saying, don't, let that horse die.
Karen, do we have anything on our agenda?
Actually, for your hearing on September, or your meeting on September 22nd, the only thing on that agenda is a notice public hearing on this particular ordinance. And a lot of that was just, trying to be responsive to city council and the moratorium and just keeping things going. And I really don't like having to post that notice in advance of like a work session like tonight. So it was definitely a gamble. But we can certainly cancel that hearing and instead do a work session.
Karen, I don't know who makes these decisions, but when I spoke with Michael, he's like, why are you having a work session and a public hearing before the city council? I mean, I think to the point of Larry's point is like, maybe just continue the public hearing and, instead of another, because it's gonna like a vacuum, we're just gonna like keep, let the next meeting be the public hearing, but I understand you want more time to review and then have the city council meeting.
Meaning we would continue and not table, but continue. If we didn't come to agreement or had quite a bit of public input on the 22nd, then we would continue it if we were not.
Oh, that's even better, actually. That's even a better idea. Because if you do, then you move forward. And like I said, it's kind of like, well, I don't like, again, I don't know whose authority it is. I just don't think the city council really wants it back to them, at least.
I'll go back to my opinion of that they created that obstacle, not us. We want to make sure we do this right.
My intent, yeah, I agree with that. My intent is I want to have the public have the ability to read the proposed ordinance, understand it, and be able to comment on it.
Well, if
Plenty of
Nina has opportunity, we should have something to publish by the 15th.
Yeah, I mean, I want to just what's on my fresh in my mind. I've been writing what you say. So and it's going to be, you're still going to see things that either I missed or you still want to talk about, but I can get this early next week, the draft. So that gives people a week and a half to look at it and then publicly comment, and then also publicly comment in front of the city council.
And could we actually do, and this is a question for Karen, it's very press release saying that the planning commission will be conducting a public hearing on this particular issue. If you'd like to see a copy of the regulation, it's available online or whatever.
The website does that if
Does that, and you have
Due
notice in the
diligence.
paper?
not anymore.
The notice for the 22nd, I believe, ran yesterday.
And then I think we could just talk to Grace and just have extra publicity on this. Is that what you guys are saying on the Facebook page?
Yes.
That's fine. And then you could decide on that date if you do want to continue, but I would say I would push you to have start a public hearing at least, because you might be in a good spot where you think, okay, it's good to give to council. And then I need to know by then by the end of September, draft extension of the moratorium, because either way it's necessary. It needs to be passed by October 6th. So I need to know what I'm drafting for, like, where you guys are at,
It's awfully embarrassing to have people come to us and say, we did not have a chance to read this. Where was it available? We couldn't tell them.
Yeah, that's the first time I've ever seen that, so.
That's not.
Well, and I will own that. I apologize that that wasn't clearly and readily available on the city website. Notice of tonight's work session did run in the paper. So that actually, that was out there saying that, you know, tonight is a public work session or a work session related to this particular topic. And yeah, just my apologies that we didn't actually get the draft regulations, you know, up on the city website. So for the September 22nd, are you guys wanting to go straight into a public hearing? Or are you potentially wanting to like continue that and do a work session and then open a public hearing at night?
I think we
or-
should, I think they said they'd want to do a public hearing and they could always delay it if necessary, but it's,
If we can't resolve the issues on the 22nd, we
but
can
we should at
always
least try,
continue
especially
into the
given
next
what the rest.
meeting.
Mhm.
So I think we go forward with the public hearing as advertised, and then if we need to extend it because there's too much to modify, then we can do it at that time.
Okay,
We'll have Nina's draft. And we can hear public comment on that draft because it can be presented to the public in time for the meeting, correct?
yes.
So we
Assuming
can
I
take
get it from
public
Nina.
comment on that, even though they may say, hey, we don't like this. And we say, that's a to be determined by us. We haven't decided on that yet either. Then they'll hear that from us.
And we can
Public hearing.
recommend changes to the ordinance at
Yeah.
that meeting.
And
if
that's what goes in front of
necessary.
city council.
And we could potentially finalize that in our discussion after the public comment
Yeah. public-
and move forward.
Yes.
Okay, before it turns to be the next day for Karen in Florida.
I
uh,
know, God.
Is there anything else that we need to discuss tonight? If not, thank you, Karen. Get some good sleep. And I'll do the same, I think. And
Thanks, Karen.
if nothing
Yes, thank
else, meeting's adjourned.
Thank you.
Thank you, everyone.
9:57.